With your permission, can we start? Prakul Bhaiya? Am I audible? Am I audible? Hi, Ayush. Can you hear me?
Yeah. Hi, Priyank. I can hear you.
Yeah, sure. So good afternoon, everyone, to this second day of the corporate law.
Priyank, Prakulji has requested to just wait for 1 minute. I think he's setting up his screen.
Right.
Yeah, you may go ahead. I said I'll share my screen as and when you want me to. So we may go ahead. Thank you.
Sure. Okay. Yeah. So good afternoon, Bhaiya, and good afternoon to all the participants to the second day of the corporate law conclave, theme decoding compliance and complexities. We are all the fag end of filing ITRs for individuals. So without wasting any time, I'll just quickly introduce our speaker for the day, CS Prakul Thadi. Prakul is partner at Prakul and Kuarpreet LLP Company Secretaries. He is an insolvency professional practicing company secretary, lawyer, and a cost accountant with prior experience of 3 years in Natco Pharma Limited, a listed entity with more than 2,000 crore turnover in its litigation and secretarial team, during which time he has also assisted the promoters in their private equity investments. Thereafter, Prakul pursued graduate insolvency program to become an insolvency professional. As part of the program, he has undergone a 9-month practical training with EY, assisting successful implementation of resolution plan of a large steel manufacturer based in Maharashtra, and played critical role in compliance management, litigation, plant visits, and operations oversight in a Bhuj-based auto component manufacturer undergoing CIRP. Post that, he is trained under the guidance of the judicial and technical members at NCLT Chennai for 3 months. After an extensive training for 2 years, he enrolled as an insolvency professional with IBPI. Prakul is appointed as the interim resolution professional in the matter of CIRP of Messrs. Surya Landmark Developers Private Limited. He is also nominated as the RP by Yes Bank Limited in the matter of insolvency of personal guarantors to a corporate debtor. He is currently appointed as a resolution professional in the matter of insolvency resolution process of Mr. Sanjay Rajkumar Chhabariya. With this, I welcome you, Prakul, to our platform of ACAE, and we wish to have a wonderful discussion ahead. Over to you, Prabhu.
Yeah. Yes, sir. Thank you so much, sir. Yeah. Thanks for the introduction, sir. I'm sharing my screen without any delay. Yeah. So since we just have 1 hour of time, so what I tried to do in this presentation was to compile all the key factors which are relevant for company secretaries in terms of compliances, both under SEBI as well as the Companies Act, when it comes particularly for implementing resolution plans under IBC. So before I go forward, I just want to set the context right. So the context at which we are discussing this is that a company has undergone CIRP successfully, and it is at the last stage, that is when the plan has been approved by the adjudicating authority, which means the closure of the CIRP, the closure of moratorium, and a new applicant, or a new promoter. It can be, a successful resolution applicant. For the sake of a discussion, we can call it a successful resolution applicant. A successful resolution applicant is in the process of implementing whatever has been stated in the resolution plan, and the intent is to acquire control over the company. Now, as we all know, acquiring control over a company is predominantly any applicant wants to do 2 things. 1, he wants to change the board of directors. 2, that applicant wants to acquire the entire capital of the company. So predominantly in majority of the plans, I would say more than 95% of the plans, unless it is submitted by a promoter himself or herself, the plans would include these two key factors. And that's where we as company secretaries step in to read the IBC alongside Companies Act to provide compliance solutions in a way that we are not compromising with any of the provisions or any of the provisions. The simple, as I said again, the context we are dealing with is in terms of implementing a plan. So for which we have to always fall back on what is contained in the plan. So the Companies Act, the compliance of Companies Act and the SEBI will go hand in hand, but will also be subject to some exceptions and provisions provided in the resolution plan. So what you see on the screen are major steps which are usually involved in any of the resolution plan. So which include constituting a monitoring committee or an agency, extinguishing the entire existing share capital or part of the share capital, delisting of securities if it is a listed entity. And the purpose, as we can see, is to have a closely held company. Then issue an allotment of securities. So once you extinguish the entire capital, you need fresh capital coming in. So the fresh capital allotment and issuing the capital and allotment of it is also one of the major ingredients of any resolution plan. Then followed by reconstituting the existing board of directors. Then depending upon the kind of securities the creditors hold till that point in time, we also will deal with satisfaction or modification of charges. So as you can see on the screen, none of these are new factors for a company, for a practicing company secretary particularly, because we do this day in, day out for all the companies. However, when it comes to IBC, there is a peculiar situation because there is a shift in management. There is a way we do these things when it comes to a CARP scenario or an IBC scenario. That's particularly what we are going to discuss today in our session. First and foremost, we need to understand what is a monitoring committee. Is it a committee under the IBC? Does IBC provide for any provisions for constituting a monitoring committee? The answer is absolutely no. IBC is purely silent. It doesn't provide for any such committee at all. It is a pure market practice. Now, why did this market practice evolve? What is the reason? So the reason is section 32B read with regulation 38, which provides that there is a need for monitoring, implementation, and supervision. So the code and the regulations very clearly say that the implementation has to be monitored and supervised. It doesn't say how. It says that the plan has to provide for a manner in which this resolution plan shall be implemented and how will it be monitored. So the plan has to address this, saying that this is the manner in which it will be monitored. So a common market practice which has evolved is saying that let's have a monitoring committee, which usually comprises of a representative from the creditor, that is representative from the COC, one representative from the resolution applicants, and usually even the insolvency professional who acted as a resolution professional will also become part of the committee. So usually a 3-member committee will be formed who will oversee what is happening in terms of implementation. Now, just by having a committee, does it get powers on its own? The answer is no again, because IBC is silent on it. So usually what they do in a resolution plan is that they empower this committee with all such powers which a board has, right? So generally these powers are nothing but, so during a CARP process, a resolution professional exercises such powers of the board of directors and the existing directors' powers are suspended. Now in a resolution plan, the usual practice, again, as I say, it's a practice, is to suspend the existing directors' powers even subsequent to the approval of the plan till the time the plan is implemented. And till the time the plan is implemented, the monitoring committee will continue to exercise such powers, subject to some restrictions and subject to some reserved matters which cannot be dealt with by such monitoring committee. So this is usually the role of a monitoring committee. And the critical importance of monitoring committee comes as and when we go forward in a plan to implement the plan. Now, today in this session, we don't debate on how the payments are made by the applicants to the creditors. Our only debate will be on how we implement all of it by way of complying with the laws. Now, first and the foremost, we need to understand the relevance of extinguishment of existing share capital. Now, as again I said at the beginning, a control of a company is usually through, or rather you would say that is 100% by way of acquiring the majority share capital in the company. Now, when we go by waterfall mechanism, shareholders always stand at the end of the list, which particularly means when the resolution applicant provides for settlement of all the stakeholders, including shareholders, usually the shareholders will not get any return from this particular resolution plan, particularly because the valuations of the company deteriorate to a level where there is no value left to the shareholders. So that's the whole purpose why capital gets wiped off. However, wiping off the share capital will be the last step in any resolution plan. The reason why it is a last step in any resolution plan is because, of course, I mean, last in the sense, just before allotment, this would be the step which any company undertakes. The reason why we do that is because the moment you extinguish capital and allot new capital, you gain control over the company. So unless all the payments are made to all the stakeholders, this step will not be encouraged. But today we take an assumption that all the payments have been made. That's why I'm taking this as the first step in our discussion. So in order for extinguishment of share capital, particularly equity share capital, we refer to Section 66 of the Companies Act. But as we see, Section 66 of the Companies Act also mandates an application to be made before the tribunal, NCLT. But this resolution plan in itself is approved by the tribunal, number one. Number two, when an insolvency, when under IBC a plan is being approved, that's a code in itself which tries to addresses everything within the power of the tribunal. So generally, wherever an extinguishment of existing share capital is being proposed, the plan also proposes two things. Number one, relaxation of compliance of Section 66, because it's already within the purview of the tribunal and the tribunal is approving it. And secondly, few plans also debate that Section 66 will not be applicable in this case because this is an integral part of the plan as it addresses the stakeholders, as it addresses the repayment or rather settlement of the stakeholder, particularly the shareholder. So there is two ways of looking at it. Either we seek for relaxation of the compliance of Section 66, or we kind of debate in our plan that it will not be applicable in the case of an IBC for the simple reason that it is an implementation. I mean, it is a resolution plan proposed even to say for the settlement of shareholders. And since it's a code in itself, this particular provision of complying 66 separately has never been debated because the tribunal itself is approving the reduction of share capital. And even in the orders approving resolution plans, the tribunals usually mention this as a separate clause, or separate para, trying to address that the share can be reduced or can be extinguished in this fashion. And even the requirement of using the terms and reduced at the end of the name is always relaxed. So any resolution applicant who successfully reduces the capital by way of implementing the resolution plan, they need not use the terms and reduced at the end of the name of the company. However, it is advised that such an intimation be made to the ROC. So the only problem in case of extinguishment of capital is that it won't get reflected as there is no specific form for it. It will get reflected only when you file pass 3, that is return of capital. Allotment of shares once you do. As a subsequent step, the updated capital will get reflected on the master data, or you will do it as part of the annual return. But nevertheless, as and when we do an extinguishment of capital, it is advisable to intimate the ROC that the capital has been reduced because of so and so, that this has been the resolution plan and this is the extract of the plan pursuant to which the capital has been reduced. Now, other steps which we have to do in terms of affecting extinguishment of capital, particularly when the company is a listed company. So things become complex when we know that the company is a listed company and there are thousands of shareholders or lakhs of shareholders involved whose capital is getting reduced. Now, as part of industrial practice, I've seen two ways of doing it. One, in the case of Essar Steel, which was a listed company before acquisition by ArcelorMittal Nippon Steel. And after acquisition, the name got changed to ArcelorMittal Nippon Steel. But at the time of implementation, what they did smartly was, instead of going for a delisting and then subsequently effecting an extinguishment of capital, they initially went for extinguishment of capital and informed the record date on the stock exchange. Okay. So what they particularly did was, firstly, they filed a corporate action form with the depository saying that this, as per the resolution plan, as per the terms of the resolution plan, reduction is an integral part. And hence, because pursuant to this, we are reducing the capital. And both NSDL and CDSL have customized checklists when you submit corporate action forms for extinguishment of capital, particularly as part of implementation of resolution plan approved by the NCLT. So they have customized checklist. So whenever we follow with the depository, we have to specifically inform them that this is not a general extinguishment under Companies Act. This is an extinguishment pursuant to approval of resolution plan under IBC. So that's when they provide us with the customized resolution plans. Sorry, customized checklist for extinguishment of share capital. Then once we fix the record date, that is the date subsequent to which the shares get cancelled, that has to be informed to the stock exchanges. Now, once we submit the resolution plan and all these documents to the affect such extinguishment, and subsequent to such extinguishment, the existing ISIN, that is the identification number of that particular security, that's the equity, it gets deactivated. And when we file subsequently for a new issuance, that gets activated, right? So that's we will take it up when we deal with the issuance of security. But now, as I said, the two practices which ArcelorMittal did, one practice which ArcelorMittal followed in SR Steel case was that without separately doing compliances for delisting, they immediately filed for extinguishment first. So even when the company was listed, all the shares of the company got extinguished right when the company was a listed company. Then subsequent to the complete extinguishment of the existing shares, ArcelorMittal then applied for delisting, saying that the entire share capital of the existing shareholders got extinguished, and hence the NSE and BSE may give their NOC for delisting of the securities. Now this provision of delisting we will deal with on the subsequent slide. But what am I trying to say here is that instead of first affecting the delisting and following the entire process and then subsequently doing a new process for extinguishment, SR Steel had followed this by way of first applying for extinguishment, then going for delisting. Now, there is also another way of doing it, is to first you may apply for delisting, get yourself delisted from the stock exchanges. Then parallelly, you may also initiate the process for extinguishment. And as and when it is delisted, then subsequently the extinguishment will be effected, then the entire share capital gets extinguished. So these are the two practices prevalent in the industry. When I personally did one case in the listed entity, we did the other way around. That is, first we applied to NSE and BSE for their NOCs for delisting as a part of the resolution plan. And again, NSE and BSE also have a customized checklist when it comes to delisting of securities pursuant to implementation of a resolution plan. So we complied with that, and then we obtained NOCs from both NSE and BSE, and we submitted our NOCs. The NOCs received from NSE and BSE to the depositories, wherein they mark the company as unlisted on the records, and subsequently we have effected the extinguishment of share capital. So this is how we followed in terms of extinguishment after delisting. That's what I personally did in one of the matters. But in the other matter, as I said, in ArcelorMittal's case, where it acquired SR Steel, they have followed the other way around. But the crux, what I want to highlight from this slide is that this particular modus operandi of extinguishing your capital and delisting should be completely prescribed in your plan. The plan has to address as to how you want to affect this particular step of extinguishing the capital or delisting of the securities. The plan has to very clearly capture the timing of it in the implementation schedule. So that's from the plan we do all this. So why did I go for delisting first and then apply for extinguishment? Because in the plan which I was implementing, the plan very particularly stated that first step will be delisting, and subsequent to that is where I have to go for extinguishment. So since the plan is approved by the NCLT, and as per section 31, the plan is binding on all the parties, including the corporate debtor, that is the company. So I have to stick to what is provided in the plan. So this is the discussion on extinguishment of the existing capital. And this extinguishment can extend to the other securities as well. So if the company has any other securities, including preference share capital or other debentures, all such extinguishment can provide, the plan may provide for extinguishment of preference share capital as well. The plan may provide for redemption of other securities as part of the implementation of the plan.
Prakulji.
Yes, sir.
Yeah, I have just one small doubt.
Yes, sir.
So in case of delisting of shares, we are required to report to the exchange within 1 day of the approval of the resolution plan.
Correct.
But if we are carrying out the extinguishment of the shares prior to the delisting, then we will not be able to report within 1 day about the proposed delisting to the on a timely basis, because we are first carrying out the entire extinguishment process and then we are applying for the delisting.
Correct. But no, sir, I'll tell you that. So there are two things. Firstly, as you can see on the screen, the recent regulations, 2021 delisting regulations, have specified that these regulations will not apply if the delisting is made pursuant to a plan approved under Section 31 of the Code. Which means if a plan is approved under IBC, the delisting regulations themselves do not become applicable as per Regulation 3.2b. So these intimations and obtaining NOCs, and of course, obtaining NOC is mandatory, without which we cannot delist from the stock exchange. That goes without saying. But the timing of it can be managed by way of providing under the resolution plan. That's what I'm trying to say. Because the regulations very specifically say that these regulations, the delisting regulations will not apply where such delisting is made pursuant to a resolution plan. And it continues to say, if such plan provides for delisting of such shares or an exit opportunity to the existing public shareholders at a specified price. Now, this exit opportunity is a very rare scenario where if a promoter is suppose, let's say a promoter is offered a particular opportunity, then at least at that price, other public shareholders have to be offered exit opportunity. And in case of, if you are getting it at any price, the second point, that is details of delisting along with justification for existing price in respect of proposed delisting shall be disclosed to the stock exchange within 1 day of approval of the resolution plan. So here in the second point, it is, basically these two provisions are pertaining to only when you provide for an exit opportunity. The moment you do not provide for an exit opportunity, this does not become applicable. Both the provisions do not become applicable, number one. And number two, the delisting will be as per what is provided under your plan. So what you are trying to highlight, no, sir?
I think this clarifies.
Yes, sir. Yes, sir. So only when there is a exit opportunity, we will have to immediately and you're right at that point. At that point, I cannot do things like extinguishing the capital and then going for delisting, because I have to first get the delisting done, give the exit opportunity, make the payment. Only then I can go for extinguishment. So thanks for raising that point, sir. Actually, this indirectly covers my second slide as well. But nevertheless, let's discuss on the delisting of securities front. So delisting of securities, as we just discussed on the previous question. So delisting of securities of any kind, and when it comes to listed companies, of course, is dealt with by SEBI Delisting of Securities Regulations 2021. And this regulation 3.2b, which talks about the applicability of these regulations, very clearly state that these regulations shall not apply if such delisting is made pursuant to a plan which was approved by the NCLT under Section 31 of the IBC. And where such plan provides for a delisting or exit opportunity to the existing public shareholders. Now, this delisting front, when we talk about A, which is delisting of such shares, since this delisting is concerned with, I mean to say that the resolution plan shall provide the entire process for such delisting in the resolution plan, the timing as to when you do it and all that. But this, when we provide that delisting, it does not include any exit opportunity which we are providing for the existing shareholders. The moment the plan says that existing public shareholders will receive some X amount of money, then we'll have to fall back on the provisions to comply with it. That is, number one, within 1 day of approval, we'll have to immediately inform the stock exchanges that a delisting has been approved by the NCLT, and this is the exit opportunity provided to the public shareholders, and it is provided at the minimum price which is offered also to the promoters. But this possibility is very rare, because as we discussed, the value of the company deteriorates to a level where the existing shareholders hardly receive anything. Now, when we talk about delisting, I mean, this particularly is when we are talking about delisting. Now, there are situations where, if you go, I'm going back to the previous slide, which is talking about extinguishment of existing share capital. There can be a possibility where only a part of the share capital gets extinguished. When a part of the share capital gets extinguished and the other part of the share capital is still alive, which means you're not going for, let's say you're not going for delisting. I'm now talking about another, let me take another example, which is Tata Bhushan Steel Limited, right? So in Tata Bhushan Steel, the BSL, the earlier it was Bhushan Steel, now Tata Steel had acquired it by way of IBC. They did not opt for delisting, but they did extinguish the share capital. They partly extinguished the share capital. They kept 95% with them, and they're continuing and trading on the stock exchanges. Similarly, Patanjali Foods, I mean, now it is Patanjali Food, earlier Ruchi Soya. So Ruchi Soya, when it was acquired, they partly extinguished. I think 1/10 was the ratio. So for every 100 shares held, 10 shares have been continued and the rest of the shares were extinguished. So this cannot be equated with exit opportunity to the shareholders because there is no delisting proposed in such case. So delisting regulations will not even come into picture because you're continuing to list the company. That's where another regulation comes into picture, which I kept at the last, but since it is a relevant regulation, let us refer it. So at that juncture, we'll have to comply with Rule 19A of Securities Contracts Regulation Rules 1957, which deals with continuous listing requirement. So where a resolution applicant acquires a company undergoing CIRP by way of submission of a resolution plan, and if it provides for partial extinguishment of capital and continuation of listing of the securities, in such a scenario, we'll have to comply with with Rule 19A. Now, what does Rule 19A? This is particularly Sub-Rule 6. So what does Sub-Rule 6 say? Sub-Rule 6 gives three conditions. Number one, if as an effect of or as a consequence of implementing the resolution plan, if you bring down the public shareholding to less than 25%, right? If the public shareholders fall below 25%, because usually they extinguish entire 10%, only they may hardly give 5% to the shareholders, and keep the entire balance with the resolution applicant. So at such scenario, the law says, the rules currently say that you within a period of 3 years, that is a maximum period of 3 years, you'll have to make sure that you bring the public shareholding back to minimum of 25%. That is number one. Number two, if in a situation where your public shareholding as a result of implementation of the plan falls below 10%, you have to bring it to 10%, minimum of 10% within 12 months. That is within a year. So 3 years is for bringing it to 25. But in a situation where you bring it down below 10%, then at least within a period of 12 months, you have to get it back to 10%. Then the third condition, which is the minimum criteria, is that at least 5% of public shareholding has to be maintained even as a result of implementation of a resolution plan. So if we are consulted by our clients at the time of drafting of the plan, at that juncture itself, we have to advise them that if at all you're acquiring a listed company, and if you want to continue to be listed, then you have to give at least 5% shareholding to the public shareholders. The promoters may not be given anything, but the public shareholders should hold at least 5% of the entire company. And that's how the plan has to be structured. And this is where we as company secretaries will have relevance in terms of our consultation or advisory to resolution applicants who acquire companies undergoing CIRP. So this is something which we have to mandatorily comply with. So why I had to bring this, and when we were discussing about delisting, is that this giving 5% or continuing with 5% minimum public shareholding doesn't mean you're offering something to the shareholders. It is as a matter of compliance of these rules that the companies do. So currently, Ruchi Soya, as I said, Ruchi Soya and Tata Bhushan Steel Limited are two such examples. Now, Ruchi Soya and Tata Bhushan Steel both in the span of next 3 years, I think probably 1.5 2 years are already gone for Tata Bhushan Steel. So they are bringing up their public shareholding to minimum of 25% shortly. So that's the whole criteria behind these rules, and how we have to read it with partial extinguishment of shares, because this is possible only when you extinguish your shares. And extinguishment of shares read with Rule 19A always go hand in hand if you are doing it for a listed entity. Where you want to completely extinguish the share, or you want to come out of the listing and status and be a closely held company, then delisting will also add on to these requirements. So that is all about extinguishment, delisting, and continuing the listing of the entity. So these are the three things which go hand in hand. Next comes the main portion, which is of issuing an allotment of securities. Now, as a part of the resolution plan, fundamentally issuing new share capital is like 99.99%. It will be part of the resolution plan, unless, again, as I said, the only exception is where a promoter has bid for the company and the promoter wants to continue the existing share capital, then it may continue. However, in all other cases, as we know, because of 29A, promoters coming and bidding is a bit difficult because they have to pass through all the criteria. Of course, if it is an MSME, Section 240A provides a relaxation for such promoters to bid, because 29A, C and H are excluded for such promoters. So, I mean, in any which scenario, generally, extinguishment of shares and issue of new shares will go hand in hand for a resolution plan implementation. So here comes a very interesting question, particularly for a company for a company law aspirant like us, that where you are, I mean, usually some plans when I read, they provide that entire capital gets extinguished, then you will bring in new capital. But you know what happens in that flow is that you are reducing your existing capital from X to 0, and then you're increasing from 0 to Y. Now, is there a possibility to have zero capital? The answer is no. We cannot have a company without capital. There is no minimum capital, I agree, but we cannot have a company without capital. So how do we devise it is usually the plans ideally should address that. First, existing capital will be issued. I mean, first new capital will be issued. Then the entire existing capital will be reduced to the extent of this new capital. Let's say existing capital is 100. Now new capital, let's 100 crore. Let's say new capital, we only want to bring in 10 crore. So first let us do the allotment of securities to 10 crore. Then we will effect the extinguishment of securities. That is, the capital has went up to 110, but then we are extinguishing the 100 crore. So bringing down the capital to 10 crore. So the only thing is, this is a theoretical discussion, of course. Practically things go parallelly, so we will never be able to recognize that difference. But on any given day, we cannot have a zero capital on the books, and hence it's preferable when we are devising this, taking approvals from authorities, or particularly monitoring agency or monitoring committee. The seriatim of these items should be in a way that first you go for allotment, then you go get an extinguishment approved, which means first you have increased the shares, then you successfully got the extinguishment done. But so as an effect, you have made sure that there at no point in time the capital is zero. Now, coming back to the procedural aspect. So just because a plan got approved under IBC, and if the plan is proposing for allotment of securities, issuance and allotment of securities, be it equity shares or any debt instruments, does that mean we do not have to comply with Companies Act? The answer is absolutely wrong. Complying with Companies Act is mandatory. We cannot do away with it, because IBC does not provide any immunity from compliance. Only one immunity is provided. That immunity is what you see on the screen, which is with respect to approval of shareholders. Now, if you see Section 30 subsection 2, particularly the explanation to Section 30 subsection 2, it very clearly says that if any approval of shareholders is required under the Companies Act or under any other law for the time being in force for the implementation of actions under the plan, that is, for implementation of resolution plan, if you require any approval of shareholders, such approval shall be deemed to have been given, and it is not in contravention of that law. Which means once you implement this plan, and when you're going for allotment of securities, we know for any allotment of securities under 42 or 62, we would require approval of shareholders, particularly special resolution of shareholders. Now, because of explanation given in Section 30 subsection 2, that particular element alone is relaxed. Apart from that, rest of the elements will continue to be in force. Now, at the beginning stage, we have seen that monitoring agency or monitoring committee exercises the powers of the board during this phase of implementation. And that's why we will first propose the approval of resolution plan we'll first propose the issuance of securities. Approval for issuance of securities we will obtain from the monitoring agency. So basically, monitoring agency does this in two phases. Right? The first phase is where the monitoring agency approves the issuance of securities and also approves the private placement letter of offer, which is in form PAS4. Now, we know that in case of public companies, any issue opens or issuance opens once we file the form MJT 14. that is after an approval of issuance has been obtained from the shareholders. So first from the board of directors, then we will file MGT 14. Then, and then from the shareholders, again, we will file MGT 14. So that is how we do. So similar practice has been adopted. That is, once a monitoring agency approves issuance of securities, now we are not allotting it, nor are we issuing it. We are only approving the issuance. The moment we approve the issuance of securities, and also we approve the private placement letter of offer, which is form PS4 as prescribed under the respective section 42. So we will first take the approval of the monitoring agency for this. And this approval we will file in MGT 14 with the ROC. And this applies for, of course, for applicable companies. If the private company for which this does not apply, we won't file. But even for private companies, I still insist for us to, I still feel it's a better practice to file MGT 14 because we are not obtaining shareholders resolution. We can file MGT 14 saying that monitoring agency has approved and providing the explanation of section 30 subsection 2, wherein the approval of the shareholders is deemed to have been given. So that section and a small letter explaining the ROC that there is an approval of issuance of securities by the monitoring agency, which is currently exercising the powers of the board of directors of this company. And we also will give an explanation provided under the code that approval of shareholders is not mandatory. Is not required because it is deemed to have been given. And hence this is being filed with the ROC with the approval of monitoring agency. So that filing of MGT 14 is, I feel that is advisable. However, we can also take a stand that where approval of shareholders is deemed to have been given, there is no point of filing MGT 14. Even that explanation, I would definitely second. But it is better in just to avoid any unnecessary review of such compliances. It is better to do that compliance and give an explanation why we are doing so. And anyways, it is mandatory if you are doing for a public company. Then second stage, after you get approval of monitoring agency for issuance of securities, second stage will be to issue the letter of offer to the allottees. Now, this may sound funny as to, because the allottees have to mandatorily subscribe to this. There is no option for the allottees, or rather it is an integral part of the plan. So now this generally the nature of letter of offer is that the allottee may reject it also, or rather the applicant may say, okay, I'm not willing to apply. While in this case, this is a bit funnier side of this implementation because it's just a paperwork which we're doing. However, as a matter of compliance, we have to do this. We have to issue that letter of offer to them. However, we all know that a private placement of letter of offer is always accompanied by an application form. Now, this application form need not be filled in and provided by the allottees for the simple reason that they anyways are deemed to be allotted, or they have that obligation to apply. It's not that if they do not apply, they cannot, they will not subscribe to it. So hence we may provide a language in the the application form that this application form may not be submitted, particularly because this is deemed to have been given by the applicants, because it's a deemed application. There is no need for a separate application letter. And why am I kind of emphasizing on it is because when we practically did this implementation, generally these letters of offer, in few cases, let's say we are issuing debt instruments to the existing bankers. In one of the plans where I implemented, we issued debt, non-convertible debentures and compulsorily convertible debentures to 10 bankers, and they are scheduled commercial banks. Now, just imagine the time within which this come back to you and submit their application forms. It will take ages for them to do it for the kind of approvals they have within their organizations. And I don't mean to say ages, I mean to say that it will take more time than what we want. And usually when we are implementing this plan, this phase comes at a time when the funds are ready and the funds are cited in their particular accounts. So the investors are behind you to do the compliances, right? And the creditors are behind you to get the compliances done. So this is a particular phase where we cannot or we cannot get more time for compliances alone. So hence our compliances have to be done, but they have to be done in a completely time-bound manner, because the funds are ready, the recipient of funds, the creditors are waiting for the funds to come. So at that juncture, they cannot expect us to take more time in doing these compliances, like getting the application form back. So as far as possible, we have to make sure that the documentation is strong. At the same time, where there is no such requirement of follow-up documents, we may have to take a relaxation on that. So particularly for private placement letter of offer, where an application form is also prescribed, we may specify there on the application form that this is deemed to have been applied because this is implemented as part of the resolution plan. Then subsequently, as we know, if it is an equity capital, getting the funds into the account is mandatory. So opening a separate bank account for subscription, we will get an approval from monitoring agency, open a subscription account where monies will flow in. And once we cite those, once the monies are cited in those accounts, only then the monitoring agency will again convene and allot the equity shares. And if it is a conversion of debt, where we provide equity to creditors as a conversion of debt, or where we issue securities to creditors as conversion of debt, any debt instruments are provided, let's say convertible NCDs are provided in lieu of the existing debt, then for that there won't be any funds received, and hence this step of citing of funds will not be necessary. And once monitoring agency allots, so here we do not have board in place yet. Okay, so monitoring agency is only exercising the powers of the board. So monitoring agency, once it allots the equity shares, within 15 days we will have to file the written of allotment in form pass 3 with the ROC, and this entire capital gets reflected. And this particular requirement of filing of pass 3 will again be critical, because that's the most important element to be done. And the reason again is, unless you file pass 3, you cannot use the funds, and hence filing of pass 3 again becomes extremely important at that particular stage, particularly when you are proposed in your plan that the equity infusion will be utilized for payment of creditors. Then it becomes much more difficult. So that's why filing of pass 3 usually will be done immediately in next 24 hours. We don't take the liberty of time for next 15 days to file it. We usually file it within 24 hours, particularly when we are implementing a plan. So when we file the return of allotment, of course, we will provide an explanation how these allotments have taken place and the entire history, along with all other attachments, that is list of allottees and pass 5, that is record of private placement. All of this we provide as part of the pass 3 filing. And this is with respect to allotment. And once allotted, if the securities are in dematerialized form, then we will have to parallelly apply for master creation for a new ISIN to be provided for the securities, depending upon the kind of security, be it equity, debt instrument. Then we will also file CAF, corporate action form, for the purpose of crediting the securities to the respective demat account of the allottees. So if it is dematerialized, if the securities are dematerialized, that's when coordination with depositories also will come into picture. So that is with respect to allotment of securities. Now, next stage is with respect to reconstitution of board of directors. Now, again, IBC is silent on this. IBC we cannot assume that just by way of approval of plan, the existing directors vacate their office. There is nothing prescribed neither in the Companies Act nor in the IBC in terms of the status of the existing directors. Even this has to be provided in the resolution plan. So when we draft the resolution plan, we have to ensure that even this point on reconstituting the board of directors is duly taken care of. It as we know, it contains 2 important steps. 1, appointing new directors. 2, cessation of directorship of existing directors. Now, cessation of directorship of existing directors, in majority of the plans which have gone through, they usually provide that upon the approval of this plan, or upon the closing date, or as on the closing, that is after the implementation of the plan, the existing directors are deemed to have resigned and vacated from their office as directors. Now, the moment we say deemed to have resigned, there is one way of doing it, that is purely based on that clause, we can apply for cessation of directorship of those directors. But as we see, as practicing company secretaries, we know the difficulties. Unless there is a whole-time company secretary in the company, filing of forms will become quite typical, because only directors may file for such changes in directors and all. We need the DSC of the existing director. So in one of the companies where we implemented, where there was no company secretary as well, so what we did was we requested the existing director of the erstwhile promoter board to provide his DSC, in the sense that we have requested his office to affix the DSC for filing of these forms. So what did we do? We first appointed the new directors using that form, using that DSC. So these new directors will be proposed to the monitoring agency. And generally, when we appoint additional directors, we take approval from the board of directors. Since monitoring agency is exercising the powers of board of directors, we will take approval from the monitoring agency by way of a resolution, wherein the resolution applicant will propose the names of the new directors, and the monitoring agency usually appoints them as additional directors. And such appointment of additional directors, we will file in form DAR 12 by way of one form wherein new directors have stepped in. Now, since a new director has come, the new director's DSC can be utilized for resignation of the existing directors. Now, there are 2 ways of doing it. Either you take resignation letters from such existing directors, or since the plan provides for deemed resignation, we can go ahead with the extract of the plan and tell the ROC, because it's an STP anyways, but we can explain it as part of the explanation, other attachments. We can explain that as part of implementation of the plan, the directors have deemed to have been resigned. Now, for further or for additional caution, we may get a resolution passed by the monitoring agency that these directors are deemed to have been resigned, and necessary forms, necessary intimation may be made to the ROC, and things like that we can do by way of the resolution, and even that resolution can be attached to the form DR12. So 2 DR12s we will file, one for appointing new directors, and once that we will file with using the DSC of one of the existing directors. And once the new directors come in, then the new directors will file another DSC for removal or for cessation of directorship of the existing directors. Now, this has become easier for us when I was doing implementation for a public company having a CS, or also for a listed entity. There were 2 group companies. So when I did implementation for a listed company, it became particularly easy because that listed company, because that listed company has a company whole-time company secretary. So we did all the filing through the company secretary, and it has been really easier, because usually listed companies have the compliances on with the SEBI and also, which means usually all the compliances are on track. So it becomes really easy in such companies. But if it is in an unlisted company and there is no company secretary, and there is no if suppose INC 22A has not been filed and the company as status is inactive on the ROC, that's when it becomes really difficult. So that's where we did one such case where we did all the filings through form GNL2. Because usually for resolution professional under CARP, all the filings they can do through GNL2. So even we have experimented the same. We did the pass-through to GNL2 and got it on record. Then we did reconstitution of director. Because we could not file for the change in directors unless, for additional directors we could, but for appointing other, for doing other filings we could not because of the INC 22A bar. And hence, for INC 22A to happen, then we had to follow up with the ROC and do all other filings and all. So it's a bit complex when it comes to companies which are not listed and which do not have adequate compliances in place. Then it's of course it's as per the Companies Act only. There's nothing IBC can do about it. So we have to follow up with the ROC and get all other forms done. But only relief the resolution plan provides is that at least for previous offenses, that is previous delays of the erstwhile directors, we may take a condemnation from the respective authority, even from NCLT, depending upon the penalty involved. We can get the condemnation easily because there is no fault of yours in terms of such non-compliance. So that's the only thing we can do. As I have kept it on the board at the last para, is for implementation, particularly for reconstitution of board of directors, we will have to fall back on the resolution plan. And one important thing, when we are advising a client to draft a plan, or when we are drafting a plan for our client, it's very important to capture this provision on reconstitution of board of directors, because in the absence of any provision on reconstitution of board of directors, the existing directors will continue to be in force. So which means as a mistake, if we even by mistake we ignore to provide clauses on reconstitution of board of directors, then the existing board is deemed to be continued in power. And if you want to remove them, you will have to comply with the provisions of the Companies Act for removal of directors provided under respective section to ensure that compliance is being done. That becomes really complex if the directors say that we are not going to submit a resignation, and if they want to trouble you, it will become really difficult. And that's the reason why, since IBC is silent, that as upon implementation existing directors are resigned or something, nothing of that sort is provided in the IBC. Hence our plan has to clearly address that situation of reconstituting the board of directors. We'll move forward. Yeah, as far as the compliances, as I said, we will take approval from the monitoring agency for appointment of new directors, and resignation letters, as I said, if the plan provides for deemed resignation, we will get it noted by the monitoring agency by way of a resolution, in the absence of which we'll have to obtain resignation letters. We have no other option. And then we'll file the same form, DR12, along with the approval of monitoring agency, and we'll also provide extract of the resolution plan, which captures the concept of reconstitution of board of directors. Yeah, sure, sir. I'll definitely share the PPT once after the session. I'll share the PPT in PDF to everyone. Then, yeah, one last thing before we conclude is with respect to modification of charge. So there are two things. Either, I mean, like the plan may provide that. Usually what will happen in any plan is that all the debt of the existing debt of all the creditors will be settled by way of the resolution plan. And once the resolution plan provides for extinguishment of the entire debt, so the existing creditors will usually release their securities. So the moment existing creditors release their securities, we will obtain NOCs from the creditors and we will file CSG4 for satisfaction of charges. But there comes a situation. Let us say we, instead of extinguishing the total debt by payment to all the stakeholders, in couple of plans we have observed that, and where I was involved for implementing the resolution plan, in both the plans the scenario was that after payment, so the payment was not done by the RA directly, the payment was done through a implementing agency, an SPV. An SPV pays off to all the creditors and gets the debt assigned to such SPV. So, and that SPV is usually a trust of an ARC. So basically what this plans contained were, they created a trust but through an ARC, and they got the entire debt assigned on that name in one plan. In another plan, there was a company which had taken the entire debt on its name. So what effectively happened was the balance sheet remained as is. If, let us say, there was 200 crore debt outstanding claims in the company, and the RA paid 10 crores for, let's say, 50 crores has been paid as settlement, full settlement for this entire 200 crore. So the bankers have approved the plan. So the bankers, let's say the creditors particularly, the creditors have received the money. So generally, and the first option, as I provided, extinguishment of debt, what will usually happen is, after 50 crores has been received, the entire balance 150 crores is deemed to have been extinguished. But in this case of assignment of debt, what's happening is, upon payment of 150, the entire debt is getting assigned on the name of the assigner, the one who is making the payment. So that SPV will enjoy the total debt and will stand on the books as a creditor. Now, what will it do with that excess debt is something which the SPV has to look into, the RA has to look into. So usually that entire debt is divided into two, one sustainable and one non-sustainable. Non-sustainable gets extinguished. The sustainable portion, they are either converting it into any instrument so that they can enjoy the interest over it, or they are converting it into equity depending upon the investment strategy of that investor. Now, particularly coming to our compliances, what is relevant in this case is that where the total debt is extinguished without any balance debt there, in the sense that we paid off some debt and the rest of the debt is getting extinguished, then we will ask the creditors to release the charges, that is to release the security. Now, that release of security, either as a documentation release of security, we will obtain a release being registered. If there was an earlier mortgage, then we will register a release deed for releasing that mortgage, and subsequently we will also obtain NOC from such creditor, and such NOC will be filed along with the release deed in form CSG4. We will file it with the ROC for satisfaction of charges. But as and when there is an assignment of debt wherein the assignee is getting the entire debt along with the securities, that's when we will opt for modification of charge by way of filing form CHG1. So depending upon how we are settling of the creditors, if there is an assignment, we go for modification of charge, that is by filing form CHG1. If there is satisfaction of charge, that is by way of paying the entire debt and paying the part of the debt and getting the balance debt extinguished, then we'll file for satisfaction of charge in form CHG4. And for satisfaction, we'll enclose NOCs from the respective creditors and also the extract of the plan. When for modification of charge, we will enclose the deed of assignment, which gives that right to the assignee over the assets by way of, and also an extract of the plan which talks about modification of charges. So this way, either satisfaction of charge or modification of charge has to be opted by us, and accordingly we will file respective filings with the ROC. So when only one point on assignment of debt, I know we have reached 4 o'clock, but only one point on assignment of debt is that this assignment of debt has to be a duly registered document as per the respective state's stamp duty, and all that has to be duly paid off. And then once that is signed, that will be the date. From that date, the consequent approvals will, consequent filing will trigger. This date is not from the date of approval of the resolution plan. So these charge forms will need not be filed within 30 days from the approval of the plans. These will be filed within 30 days from the actual satisfaction or actual modification, that is assignment. Only from that date, the 30 days period will be triggered. So this is all about the compliances under the Companies Act and various steps involved. Only one factor which which we have to discuss, it's the last slide, is with respect to SEBI's regulations, listing obligations and disclosure requirements regulations of SEBI, wherein in the Schedule 3, discussing with disclosure of material events, it also specifies in the 16th line item, it tries to specify that once the plan is approved by the adjudicating authority, you have to disclose the details of the plan, basically salient features. So earlier it just said salient features of the plan, and all the applicants used to give only very basic details which does not contain key elements of the plan. And that's when this sub-regulation got amended. The schedule got amended to specify what all have to be there in your specific details. And it also says those which involve commercial secrets may not be disclosed, but these basic details has to be disclosed. So whatever you see on the screen, so we'll have to prepare a detailed letter to the SEBI containing all these details and submit it to the SEBI immediately once the plan is approved. So this is the requirement as per the SEBI LODR regulations. So under SEBI, we have seen LODR regulations, delisting regulations, and we have also touched based on the Securities Contracts Rules 1957, particularly with respect to implementation of plan. I didn't go in detail, I know that, but only with respect to implementation of plan, these three have been the changes made in the SEBI regulations. And when it comes to Companies Act, this, in the sense, Companies Act read with IBC, this explanation to section 30, subsection 2 of IBC is very relevant, because we will never obtain approvals from any shareholder for implementation of anything in the plan. It may require approval of shareholders under the Companies Act, but we will not obtain it because the explanation is very clear that such approval is deemed to have been given. So these four are the legislative changes brought in, and rest of it, as we have discussed, these steps go as part of the implementation of the plan. The plan will usually specify what are the major steps involved in implementing the plan. So with this, I conclude my presentation, and thank you so much. I will definitely share my presentation to everyone. Thanks for that.
Yeah, thank you, Prakulji.
Anji, sir.
Is anyone having any questions?
Yeah,
I think we can take a couple of questions if required.
Sure, sir.
Yeah, I think Prakulji, no one has any questions at the moment.
Great, no problem.
I'd like to give a formal vote of thanks. Thank you, Prakulji, for joining with us today. It was really an enlightening session. I think the time did not do justice to you, and
no problem.
you had much more to share.
Yeah.
And I think implementing the resolution plan is cannot be dealt with in a couple of slides or a huge momentous task.
Correct.
I'd like to share a small e-memento with you.
Oh, that's nice. Thank you.
Yeah, we'll be sharing this across to you over email as well.
Sure, sir. Thank you so much
for your participation today. Once again, I'd like to thank you, Prakulji, for joining with us today.
Thank you so much
for the session.
Yes, sir. Thank you, sir. Thanks, everyone. Thank you.
Thank you.
Bye, sir.
Diveshji.
Hello.
Hello.
Yeah. Yeah. Hi. How are you?
Yeah. Hi, Diveshji. So I'll just first formally welcome Diveshji today.
Thank you.
CS Divesh Goyalji has joined us today for his deliberation on new LLP related provisions. I will first formally introduce him. He is a fellow member of the Institute of Company Secretaries of India, having intense expertise in corporate law for the last 9 years. He is a young and progressive practicing company secretary with zeal to dig deep into nuances of corporate laws. Being a researcher at heart, he has done meticulous research and has penned various articles on the Companies Act 2013 to keep at pace with the latest changes and critically dissect the implications of various provisions of the new Act. He has co-authored the Company Law Premier Book published by the Institute of Company Secretaries of India. He has also added a lot to the issuance of various guidance notes by ICSI. He was a member of the Task Force Committee and Research Committee for 3 years. He is a member of various committees of the NIRC of ICSI. His articles have been published in ICSI magazines and are available on various popular websites relating to corporate law. He has deliberated at several forums on corporate law throughout the country. Over the last 2 years, he has deliberated for more than 200 seminars and penned approximately 800 articles on multiple topics of corporate law. He is running a portal for vacancy for CS members oblique trainees to help the fraternity. He is holding workshops and uploading videos through YouTube on regular basis. With this, I would welcome Divesh ji and would request him to take the session forward.
Thank you so much. Thank you, Ash, for the brief introduction. So first of all, I would like to thanks to the ATS for giving me an opportunity to interact with all the members and all the participants. As Association of the Corporate Advisor and Executives have given me this opportunity. Thank you so much for this opportunity. So as today, I can say the topic which is assigned to me is the amendment under LLP Act. As we know, we are the professional, as a, we can say, chartered accountant, as a company secretary, as an advocate. It is most important for us to keep update ourselves. The most important thing I can say as a professional, we have to keep ourselves updated. So for that purpose, definitely I can say this is a great move by the association for knowledge sharing with everyone. So every day we know there are the amendments we are facing in every act. These days, if you will say about the Companies Act, you are saying you will see so many amendments are there. If you will see about the SEBI, RBI, GST, everywhere there are the amendments. So the most we can say challenging thing as a professional, and the most challenging thing with a professional these days is to keep themselves updated. This is one of the most important challenges in front of the professionals. So today we are going to discuss about the LLP Amendment Act. LLP Amendment Act, and I must say LLP Amendment Act is one of the latest and the great move by the Ministry of the Corporate Affairs. Why I'm saying this is one of the greatest and one of the latest and great move, because LLP Act की अगर हम बात करते हैं, if we talk about the LLP Act came into 2008. It passed into 2008. Since 2008 till date, there are no amendment under LLP Act. Means you can say act is there and there is no amendment in that act since its incorporation, since 2018. This is the first time in 2021 when ministry came with the amendment under the LLP Act. See, जनरल क्या होता है, जनरल कुछ नोटिफिकेशन की हम बात करें, सरप्लस की बात करें, वो आते रहते हैं जाते रहते हैं. But the most important thing, the amendment under the act. So this is the first time in approximately 15 years when ministry came with the amendment under the LLP Act. And definitely these amendments are very big amendment, and lot of things they have changed by this amendment act. So one thing I just want to request to all the participants, if anyone have any query, any question during the session, please feel free to ask your question, ask your query during the we can say discussion itself, so that we can try to resolve that. So let me try move to the next slide. So the most important thing, when this act has been passed. As we know, in India, whenever we have to pass any act, there is required to take approval from the both house of the parliament and president of India. So approval from the both house of the parliament and the president of India is most important for the passing of an act. So this LLP amendment bill first time passed by the both house of the parliament on the 28th July 2021. On 28th July 2021, it has been passed by both house of the parliament. And the most important thing, even after the approval of the both house of parliament, we cannot say that act become an act. It became an act by the assent of the president of India. On 13th August 2021, first time we received the assent of the president of India, and this LLP amendment will become a LLP Amendment Act. And finally, on the 12th February 2022, Ministry of Corporate Affairs issued a notification, and they said all the amendment of the LLP Amendment Act will be applicable from the 1st April 2022. So we are in the month of July. This amendment act, this LLP Amendment Act has already been implemented from the 1st April 2022. So 1st April 2022 was the date when this Amendment Act has been came into effect. So we know that there are the amendment, and every time, every day, there are the amendment are coming. So the most important thing, why these amendment are coming? Why? What is the purpose behind these amendments? So see, general, if I will say about the purpose behind this Amendment Act, first thing, government is want to improve the ease of doing business. We know government of India has started approximately 4 to 5 years back the concept of the ease of doing business. But once if you will not amend any act, since ease of doing business, and they said, okay, and they came with the amendment under the LLP Act. So many amendments they have made under LLP Act, which we can say which proves that yes, they are going for the ease of doing business. And the another thing is we know that the startup concept is already a very popular concept in India, and lot of companies, thousands of companies, lakhs of companies are getting incorporated under the startup concept. Now government wants the startup should come up and start business in the LLP form also, because LLP is one of the, we can say, if we compare the company and the LLP we require to do very less compliance in comparison to the company. LLP is less, we can say, costly at the time of incorporation than the company. So that's why Ministry of Corporate Affairs and the government wants the LLP should also introduce as a startup. So that's why they came with this provision under the startup. Second, to encourage the business class to incorporate LLP. We know we are having so many companies, so many LLP in India. Still so many thousands of we can say lakhs of business in India still working under the proprietorship concern and the partnership concern. So the government is here having the concern. So many businesses are still going into the, we can say, proprietorship concern, in the partnership concern. The ultimate motto of the government is all those businessmen should came into the regulated form, whether as a company or whether as a LLP. So they are making the amendment under the LLP Act to, we can say, attract to the businessmen toward the LLPs also. So this is the just basic background about the LLP Amendment Act. Now let's see how many amendments are there. If someone will ask how many sections are there under LLP Act as on date, practically many times we are not aware how many sections are there. We are aware about the Companies Act, we are aware about the GST, we are aware about the so many acts, but once it's about the LLP Act, we are not aware how many sections are there under LLP Act. So practically LLP Act 2008 is having 81 sections. And by this Amendment Act, Ministry of Corporate Affairs has added 5 new sections and deleted 4 sections, and we can say with effect from the 1st April 2022, LLP Act is having 82 sections. And we can say out of this 81 section of the LLP Act 2008, Ministry have amended 29 sections. So 40% of the LLP Act has been amended. 40% LLP Act just एक single amendment act से उन्होंने amend कर दिया है, so you can feel कि how much big amendment will be this. And what they have done, out of this 29, 5 new section has been inserted, 4 old section has been we can say omitted, and 19 section has been substituted. So after all the calculation, 82 section will be alive from the 1st April 2021 on the LLP Act, LLP Amendment Act. Now first let's discuss the most important amendment. This slide I can say, I know this is only a single slide, but this is the most important slide for the LLP Act. See, we all are aware, we all know that provision of the Companies Act are not applicable on the LLP, and provision of the LLPs are not applicable on the companies. So they both have their own, we can say, independence. They both can have their own criteria, and they both have their provision. But the first time Ministry what have done, they said now with effect from the 12th February 2022. Most important thing, this slide is not applicable from the 1st April. This slide is applicable from the 12th February 2022. So Ministry said with effect from the 12th February 2022, these 8 sections of the Companies Act will be now applicable on the LLP. So now Ministry what they have done, they have implemented some we can say very important provisions of the Companies Act on the LLPs also. So now Ministry said कि 8 सेक्शन LLP कंपनीज एक्ट के ऐसे हैं कि ये 8 सेक्शन अब सिर्फ कंपनीज एक्ट का पार्ट नहीं बनेंगे, ये 8 सेक्शन नाउ बिकम द पार्ट ऑफ द LLP एक्ट also. So what they have done, except we can say except coming with the Companies Amendment Act, except coming with the we can say LLP Amendment Act, Ministry have done one more thing. They came up with one more notification. By that notification, they said these 8 sections by that notification they said that these 8 sections of the Companies Act will now form the part of the LLP Act. Now this will also form the part of the LLP Act. So the most important thing now onwards, whenever you have to study the, we can say, LLP Act, so these 8 sections of the Companies Act you also have to study. Without reading of this 8 section, LLP Act cannot be complete. So one-sided ministry have made the amendment under the LLP Act, and other sided they have implemented so many sections of the Companies Act also on the LLP Act. So we can say in a single word, if we are working for the LLP, if we are having the LLP client, see, we all should understand one thing very carefully. The one thing is that we all have to read all these provisions again. Otherwise, we cannot serve our client. Otherwise, we cannot serve those LLP perfectly, because so many amendments are there. Not only the LLP Amendment Act, except LLP Amendment Act, they are having this notification through which this 8th section now became the part of the LLP Act also. As someone mentioned to share the PPT, I will definitely share it with the Ayush. So let me just start discussion, because our today's most important discussion on this 8th section. Except this 8th section, I will just give you a brief about the other amendments. So first and foremost, our requirement and first and foremost, our discussion should be on this 8th amendment. Section 90. Section 90 is relating to the significant beneficial owner. What ministry said, as we know, कि 2019 में मिनिस्ट्री एक नया प्रोविजन लेके आई थी कंपनीज एक्ट में, सिग्निफिकेंट बेनिफिशियल ओनर. अर्लियर कंपनीज एक्ट में भी सिग्निफिकेंट बेनिफिशियल ओनर बैंक का कोई प्रोविजन नहीं था, बट ये प्रोविजन आया था 2018-19 में कंपनीज एक्ट में. जब ये सेक्शन 90 कंपनीज एक्ट में आया था ना, तो कंपनीज एक्ट में भी लोगों ने बहुत डिफिकल्टीज, बहुत इश्यूज फेस किए थे, बिकॉज पीपल वाज नॉट, वी कैन से नॉट अगर जनरल वर्ड में मैं बोलूं कि अभी तक पीपल रेडी नहीं थे, पीपल वर नॉट रेडी फॉर दिस अमेंडमेंट, दिस बेन प्रोविजन, सिग्निफिकेंट बेनिफिशियल ओनर प्रोविजन. So finally now ministry said we will come with a section 90 under the Companies Act. But what they done, now they said that section 90, exact the same complete section 90 will be applicable on the LLP Act also. So the simple meaning is that आज तक जो सिग्निफिकेंट बेनिफिशियल ओनर के प्रोविजन आज तक जो हम कंपनीज एक्ट में करते हुए आए थे, कंपनीज एक्ट में फॉलो करते हुए आए थे, अब सिग्निफिकेंट बेनिफिशियल ओनर के प्रोविजन आपको एलएलपी एक्ट में भी कंप्लाई करने पड़ेंगे. और आई मस्ट से कि दिस इज अ वेरी बिग थिंग एंड आई मस्ट से कि दिस इज अ वेरी बिग अमेंडमेंट फॉर एवरीवन. बिकॉज क्या था, अभी तक तो सिर्फ हम कंपनी में फाइंड आउट करते थे कि हु इज द एक्चुअल ओनर ऑफ द कंपनी, but now we have to find out under the LLP Act also that who is the actual owner of the LLP and who is behind this everything up under the LLP. So अभी तक जो चीजें हम सिर्फ कंपनीज एक्ट में करते आए थे सिग्निफिकेंट बेनिफिशियल ओनर से रिलेटेड, अब वो सिग्निफिकेंट बेनिफिशियल ओनर से रिलेटेड चीजों को हमें एलएलपी एक्ट में भी करना पड़ेगा. और सबसे बड़ी चीज जो मोस्ट इंपोर्टेंट चीज है कि ये सेक्शन ऐसा नहीं है कि फ्यूचर में का एलएलपी पे एप्लीकेबल होगा. ये सेक्शन ऑलरेडी 12 फरवरी 2022 से एप्लीकेबल हो चुका है एलएलपी के ऊपर. कंपनीज एक्ट में इस सेक्शन के सेक्शन 19 के कंप्लायंस के लिए कंपनीज एक्ट में हम क्या करते हैं, कंपनीज एक्ट में हम बैन 2 फॉर्म फाइल करते हैं, बैन 1 फॉर्म फाइल करते हैं. एलएलपी एक्ट में एज ऑन डेट प्रैक्टिकली स्पीकिंग बैन 2 बैन 1 फॉर्म तो नहीं है, बट हाँ बैन 2 बैन 1 फॉर्म नहीं है. बट एज पर द डिस्कशन एज वी नो कि मिनिस्ट्री इज कमिंग विद द V3 version of the LLP. इस V3 version में they are coming with the ban 2 form for the LLPs also. So practically हम लोगों को as a professional अपना बैकग्राउंड वर्क करना स्टार्ट कर देना चाहिए. हमें बैकग्राउंड वर्क की अगर हम बात करते हैं तो हमें फाइंड आउट करना स्टार्ट कर देना चाहिए कि who are our significant beneficial owners. बिकॉज जो भी हमारे सिग्निफिकेंट बेनिफिशियल ओनर है हमें उनसे बैन 1 फॉर्म लेना पड़ेगा. और लॉ बोलता है कि बैन 1 आपको ऑब्टेन करना है विद इन 30 days फ्रॉम द एप्लीकेशन इम्प्लीमेंटेशन ऑफ द सेक्शन. Section is already implemented on the 12th February, so 30 days has been completed on the 15th March. तो आप लोगों को as soon as possible आप लोगों को find out करना चाहिए कि who is the actual owner of the your LLP, and whoever is actual owner of your LLP. अगर कोई LLP में significant beneficial owner निकल जाता है तो immediately आपको उसका ban 1 prepare कर लेना चाहिए, because we have to complete the compliances as soon as possible about the same. So this is the first section of the Companies Act 2013, which is now applicable on the LLP. So अब LLP पे significant beneficial owner के provision लग जाएंगे. So means we can assume one thing कि वन साइडेड मिनिस्ट्री LLPs को ईज दे रही है, वन साइडेड मिनिस्ट्री LLPs को स्टार्टअप में एंकरेजमेंट दे रही है, बट द अदर साइडेड मिनिस्ट्री LLPs को रिस्ट्रिक्ट कर रही है, LLPs पे वीकेंड से अपने चेकिंग बढ़ा रही है, LLPs को अपने कंट्रोल में कर रही है, ताकि पता चले कि आजकल, बिकॉज आप देखोगे ना, मोस्टली इफ आई गिव एन प्रैक्टिकल एग्जांपल, मोस्टली जितनी भी हम बोलते हैं व्हाट वी कैन से, मोस्टली जितने भी ये होते हैं रियल स्टेट कंपनीज, मोस्टली रियल स्टेट कंपनीज में आप देखोगे यू विल फाइंड आउट द LLPs holding the property, LLPs giving the funds to work to the companies. So to control them, to regulate them, now ministry said कि significant beneficial owner will be applicable on the LLP. तो LLP में भी आपको SBO के compliances करने पड़ेंगे अब आगे से, और LLP में भी आपको Band 2, Band 1 के compliances करने पड़ेंगे. अब डिटेल में मैं सेक्शन 90 में नहीं जाऊंगा, बिकॉज सेक्शन 90 में अगर डिटेल में जाए तो वी कैन से अपने आप में सेक्शन 90 एक ऐसा सेक्शन है जो पूरा 1 आवर 2 आवर का हम सेक्शन कर सकते हैं. So I'm not going into the much details under the section 90, but I have given just brief here कि section 90 is now applicable on the LLP. So read the same section, just wherever they have mentioned the company word, just read the LLP word and the same section will be applicable on you from the 12th February 2022. So this is the first section. Now the second section of the Companies Act, which is now applicable on the LLP Act, that is section 164. Now the question is that section 164 होता किस लिए है? The purpose, general purpose, if I will say, section 164 is relating to the disqualification of the director. Section 164 disqualification of director के regarding होता है. सेक्शन 164 बोलता है कि अगर एक कंपनी ने 3 साल तक रेगुलर अपनी फाइलिंग नहीं की है तो डायरेक्टर विल बी डिस्क्वालीफाइड. और 3 साल तक अगर कंपनी अगर फाइलिंग करने में फेल हो जाती है तो उस कंपनी के जो डायरेक्टर है, दोस डायरेक्टर्स विल बी डिस्क्वालीफाइड. और ये प्रोविजन आज से नहीं है, 2013 एक्ट में, सॉरी 1956 एक्ट में भी ये प्रोविजन था, और 2013 एक्ट में भी मिनिस्ट्री ने इस प्रोविजन को कंटिन्यू किया. बट द अनदर थिंग अलोंग विद दैट क्या इशू है, अब इस प्रोविजन क्या बोलता है, हमारा जो सिग्निफिकेंट बेनिफिशियल ओनर, हमारा जो एसबीओ का प्रोविजन है, एसबीओ के प्रोविजन के अकॉर्डिंग, सॉरी डिस्क्वालिफिकेशन ऑफ डायरेक्टर के प्रोविजन के अकॉर्डिंग, 3 साल तक अगर आपने एक कंपनी की फाइलिंग नहीं की तो आप डिस्क्वालीफाई हो जाओगे. आपका डिन का जो स्टेटस एमसी की साइड पे, डिन स्टेटस विल बी डिस्क्वालीफाइड. बट द इशू इज दैट मिनिस्ट्री ने पहली बार जब डिस्क्वालिफिकेशन की लिस्ट पब्लिश की थी ना, तो फर्स्ट डिस्क्वालिफिकेशन की लिस्ट जो मिनिस्ट्री ने पब्लिश की थी वो पब्लिश की थी 2016-17 में. तो उस टाइम मिनिस्ट्री ने क्या किया, ऐसे जो भी डायरेक्टर थे जिन्होंने जो 3-3 साल से किसी कंपनी में डायरेक्टर है और उस कंपनी की अगर फाइलिंग पूरी नहीं है तो उन्होंने उनके दिन का स्टेटस डिस्क्वालीफाई कर दिया. सो मिनिस्ट्री के पास बहुत रिप्रेजेंटेशन फाइल हुई एलएलपी की तरफ से कि आपने डिस्क्वालीफाई किया है डायरेक्टर्स को अंडर कंपनीज एक्ट, बट आई एम वी कैन से आई एम अ डेजिग्नेटेड पार्टनर इन द एलएलपी आल्सो. तो लीगली मैं एलएलपी में डिस्क्वालीफाई नहीं हुआ हूं, मैं जो डिस्क्वालीफाई हुआ हूं मैं सिर्फ कंपनीज एक्ट में डिस्क्वालीफाई हुआ हूं. तो व्हाई यू आर डिस्क्वालीफाई मी अंडर द एलएलपीज आल्सो. तो ये बहुत इश्यूज आ रहे थे और लास्ट 5 ईयर से एवरीवन इज फेसिंग द इशू कि एक पर्सन एलएलपी कंपनीज एक्ट में डिस्क्वालीफाई होता है, बट कंपनीज एक्ट में डिस्क्वालीफाई होने के साथ साथ वो पर्सन एलएलपी एक्ट में भी डिस्क्वालीफाई हो जाता है, जबकि एलएलपी एक्ट में ऐसा कोई प्रोविजन नहीं था. तो फर्स्ट व्हाट मिनिस्ट्री हैव डन, तो फर्स्ट थिंग तो उन्होंने ये किया कि नाउ दे सेड कि सेक्शन 164 सबसेक्शन 1 एंड सबसेक्शन 2 विल बी एप्लीकेबल ऑन द एलएलपी. अब सेक्शन 164 सबसेक्शन 1-2 के एलएलपी पे इंप्लीमेंट होने का इम्पैक्ट क्या आएगा. तो इम्पैक्ट की अगर हम बात करते हैं तो पहला इम्पैक्ट क्या आएगा, नाउ इफ यू आर डिस्क्वालीफाइड अंडर द कंपनीज एक्ट तो यू विल बी कंसीडर एज डिस्क्वालीफाइड अंडर द एलएलपी एक्ट आल्सो. तो अगर आप कंपनीज एक्ट में अब डिस्क्वालीफाई होते हैं तो एलएलपी एक्ट में भी डिस्क्वालीफाई हो जाएंगे लीगली. अभी तक मिनिस्ट्री के पास कोई ऐसा लीगल प्रोविजन नहीं था, but now the ministry having the legal provision if you are qualified under the LLP Companies Act you will be disqualified under the LLP Act. This is the first impact. अब second impact क्या आएगा, अभी तक LLP में क्या था, अगर आप LLP की फाइलिंग नहीं भी करते, if you are not doing the filing of the LLP still you was not disqualified. आपने चाहे कितने भी सालों की LLP की फाइलिंग नहीं की है, आप डिस्क्वालीफाइड कंसीडर नहीं हो रहे थे. बट नाउ द सिनेरियो इज दैट अगर अब आप एलएलपी की फाइलिंग नहीं करते हो, अगर आप एलएलपी की फाइलिंग 3 साल तक डिफॉल्ट करते हो, तो नाउ यू विल बी कंसिडर एज डिस्क्वालिफाइड, तो अब आप डिस्क्वालिफाइड हो जाओगे एलएलपी एक्ट में। तो अनदर द सेम वाइस वर्सा कंसेप्ट, एलएलपी एक्ट में डिस्क्वालीफाई हो गए तो भी कंपनीज एक्ट में डिस्क्वालीफाई माने जाओगे, और कंपनीज एक्ट में डिस्क्वालीफाई हो गए तो भी एलएलपी एक्ट में डिस्क्वालीफाई माने जाओगे। सो द मोर इम्पैक्ट हियर इज दैट, अब अगर एज अ प्रोफेशनल आप अगर एलएलपी के लिए वर्क करते हो, आपके क्लाइंटेल्स में एलएलपी भी है और आप एलएलपी को कंसल्टेंसी देते हो, तो मेक श्योर यू हैव टू मेक देम अंडरस्टैंड कि अगर उन एलएलपी ने अपनी फाइलिंग्स कंप्लीट नहीं की है तो दे हैव टू कंप्लीट देयर फाइलिंग, बिकॉज अगर वो अपनी फाइलिंग्स को कंप्लीट नहीं करेंगे तो दे विल बी डिस्क्वालिफाइड। और डिस्क्वालिफिकेशन का मोस्ट इंपॉर्टेंट इंपैक्ट क्या आएगा, दे विल नॉट ओनली डिस्क्वालिफाइड अंडर द एलएलपी एक्ट but simultaneously they will be disqualified under the Companies Act also. So this we can say, I can say this will give a big impact. This thing will give a big impact on the LLPs as well as the companies. So we should avoid this thing. We should avoid this thing under the LLPs. We should complete the filing of the LLP. So this is the second section of the Companies Act, which is now applicable on the LLP. Now the third section, section 165, number of directorship. Now this section is also applicable on the Companies Act. अब जनरली क्या है 165 क्या बोलता है, 165 हमारी बात करता है we can say number of directorship. So can anyone out of all the present member in the chat box you can message, can anyone can tell me कि a person can be director in how many companies? एक पर्सन कितनी कंपनीज में डायरेक्टर बन सकता है? एनीवन, एनी ऑफ योर व्यूज? क्यों वी नो दिस इज द वेबिनार, वेबिनार के साथ एक छोटा सा चीज क्या होता है कि थोड़ा इंटरेक्शन लेवल कम होता है, बट आई वांट कि जितनी देर भी हम डिस्कस कर रहे हैं हमारा इंटरेक्शन लेवल अच्छा हो इस वेबिनार में। So anyone would like to answer कि एक पर्सन मैक्सिमम कितनी कंपनीज में डायरेक्टर बन सकता है? एज पर कंपनीज अगर मैं बात करता हूँ कंपनीज एक्ट के अकॉर्डिंग, एक पर्सन मैक्सिमम 20 कंपनीज में डायरेक्टर बन सकता है। अ पर्सन कैन बी डायरेक्टर मैक्सिमम इन 20 कंपनीज। अब उन 20 कंपनीज में एलएलपी कभी भी इंक्लूड नहीं होती थी, हमेशा उसमें वी कैन से सिर्फ कंपनीज इंक्लूड होती थी। बट नाउ मिनिस्ट्री केम विद द थिंग दैट दे सेड कि अब जो आपकी 20 कंपनीज की लिमिट है जिसमें आप डायरेक्टर बन सकते हो, that 20 company limit will now include the LLPs also. I know this is a very big change and a very big amendment because generally क्या है what businessmen do कि they are became the directors in the 20 companies and then they are running the so many LLPs. But now this thing will be little difficult because now if they are only directors in 20 companies plus LLPs, it is not allowed. Now the limit of 20 will be applicable on the companies as well as LLPs. So this is one of the major amendment we can say under Companies Act. ये Companies Act का एक बहुत बड़ा LLP Act का बहुत बड़ा अमेंडमेंट है, क्योंकि ये LLP Act का अमेंडमेंट है बट ये इम्पैक्ट कर रहा है Companies Act को भी। That's why I'm saying कि it is a very big amendment because इस अमेंडमेंट के रीजन से क्या हुआ कि अगर आप आज की डेट में कंपनी प्लस LLP मिला के 20 नंबर से ज्यादा में डायरेक्टर प्लस डेजिग्नेटेड पार्टनर हो तो इमीडिएटली यू हैव टू टेक द एक्शन। या तो आप अपनी डायरेक्टरशिप्स को कम करो कंपनी से रिजाइन करके, या आप अपनी डेजिग्नेटेड पार्टनरशिप्स को कम करो एलएलपी से रिजाइन करके। बट एटलीस्ट एनी वे यू हैव टू वर्क ऑन इट और एनी वे यू हैव टू comply with the provision, this provision. So this is one of the, we can say one of the major impacting amendment under the Companies Act. Because why I'm saying major impacting, because इसका सीधा सीधा अमेंडमेंट क्या आ रहा है, आज तक तो हमने ऐसा कुछ किया नहीं था। आज तक तो हम n नंबर ऑफ कंपनीज में डायरेक्टर बन जाया करते थे, कोई इशू नहीं आता था। n नंबर ऑफ कंपनी में डेजिग्नेटेड पार्टनर बन जाया करते थे, कोई इशू नहीं आता था। बट अब वो चीज यहाँ पे वी कैन से कि हम फॉलो नहीं कर सकते, वो चीज यहाँ पे कंप्लाई नहीं कर सकते हैं। सो होप द 3 अमेंडमेंट विच वी हैव डिस्कस इज क्लियर टू यू। फर्स्ट हमने डिस्कस किया था एसबीओ का, कि एसबीओ के जो प्रोविजन अभी तक कंपनीज एक्ट पे लगते थे, अब स्पेसिफाई के बेनिफिशियल ओनर के वो प्रोविजन एलएलपी एक्ट पे भी एप्लीकेबल हो जाएंगे। सेकंड फिर हमने डिस्कस किया डिस्क्वालिफिकेशन, कि आज तक डिस्क्वालिफिकेशन सिर्फ कंपनीज एक्ट में एलएलपी एक्ट में होती थी, बट अब डिस्क्वालिफिकेशन आपकी एलएलपी एक्ट में भी हुआ करेगी। और एक जगह डिस्क्वालिफिकेशन होने का सिंपली इम्पैक्ट माना जाएगा कि आप दूसरी जगह भी डिस्क्वालीफाई हो गए। कंपनी में डिस्क्वालिफिकेशन का मतलब एलएलपी में भी डिस्क्वालीफाई, एलएलपी में डिस्क्वालिफिकेशन का मतलब कंपनी में भी डिस्क्वालीफाई। फिर थर्ड हमने बात की वन ऑफ द मोस्ट अमेंडमेंट दैट इज रिलेटेड टू द नंबर ऑफ डायरेक्टरशिप और नंबर ऑफ डेजिग्नेटेड पार्टनरशिप। तो अकॉर्डिंग टू दैट नंबर ऑफ डायरेक्टरशिप एंड नंबर ऑफ डेजिग्नेटेड पार्टनरशिप, उसका प्रोविजन क्या है कि आप मैक्सिमम 20 कंपनी में डायरेक्टर प्लस डेजिग्नेटेड पार्टनर बन सकते हो। हाउएवर देयर इज नो लिमिट ऑफ द शेयर होल्डिंगशिप, आप कितनी भी कंपनी में शेयर होल्डर बनो, देयर इज नो इशू। एंड सेकंड पार्टनरशिप, आप कितनी भी एलएलपीज में पार्टनर बनो, देयर इज नो इशू। बट आप डायरेक्टर और डेजिग्नेटेड पार्टनर के ऊपर नंबर्स लग गए हैं, 20 इज द मैक्सिमम लिमिट, 20 is the maximum limit of the designated partners plus directors. Hope this is clear to everyone because this is one of the very major impact. Fourth one is section 167. Now ministry said कि section 167 of the Companies Act will be applicable on the LLPs also. जो हमारा section 167 है ना Companies Act का section 167 हमारी बात करता है vacation of office, vacation in case of the disqualification of the director, vacation in the other situation like insolvency of the director and many other situation are there. So अभी तक तो क्या था, अभी तक एलएलपी एक्ट में ना तो डिस्क्वालिफिकेशन के प्रोविजन कभी एप्लीकेबल हुए थे, जैसा भी हमने ऊपर सेकंड पॉइंट पे डिस्कस किया कि फर्स्ट टाइम एलएलपी पे डिस्क्वालिफिकेशन के प्रोविजन एप्लीकेबल हो रहे हैं। तो आज तक जब एलएलपी पे डिस्क्वालिफिकेशन के प्रोविजन ही एप्लीकेबल नहीं हुए थे तो वैकेशन ऑफ ऑफिस के प्रोविजन भी मिनिस्ट्री ने कभी एप्लीकेबल नहीं किए। बट अब जब एलएलपी में डिस्क्वालिफिकेशन के प्रोविजन एप्लीकेबल हो जाएंगे तो डेफिनेटली अगर कोई पर्सन डिस्क्वालीफाई हो जाएगा तो फिर हमें उस डिस्क्वालीफाई पर्सन को वैकेंट भी तो करना पड़ेगा, उसकी पोजीशन को वैकेंट भी करना पड़ेगा। तो दैट इज वी कैन से टर्न बाय द मिनिस्ट्री कि अगर अब आप डिस्क्वालीफाई हो जाते हो, अगर अब आप डिस्क्वालीफाई हो जाते हो तो आपको डिस्क्वालिफिकेशन के साथ साथ वैकेशन भी इम्प्लीमेंट हो जाएगा। तो मतलब डिस्क्वालिफिकेशन प्लस वैकेशन बोथ विल बी इम्प्लीमेंट ऑन यू। So once you are disqualified in the company or once you are disqualified under the LLP, you will be simultaneously shall be considered as a disqualified under the other act also. So you have to keep very much focus कि आप disqualify नहीं होने चाहिए companies में as well as LLPs में, because एक जगह disqualification होने का मतलब है दोनों एक्ट में जहां जहां आप डायरेक्टर हो, दोनों एक्ट में जहां जहां आप डेजिग्नेटेड पार्टनर हो, उन सभी प्लेसेस के आपको रिमूव अपने आप वैकेंट माना जाएगा। So these are the four sections of the Companies Act which is now applicable on the LLP Act. अब सेवेंथ हम बात सॉरी फिफ्थ और सिक्स बात करते हैं 207, 206 एंड 207 सेक्शन। तो ये बोलता है कि कंपनीज एक्ट का जो सेक्शन 206 है और कंपनीज एक्ट का सेक्शन जो 207 है, ये दोनों अब एप्लीकेबल होने जा रहे हैं। 206 और 207 दोनों एलएलपी पे अब इम्प्लीमेंट होने जा रहे हैं, और दोनों के एलएलपी पे इम्प्लीमेंट होने का बहुत सिंपल फंडा है कि आज तक क्या था। सेक्शन 206 और 207 बात करता है पावर ऑफ आरओसी कि आरओसी की इंस्पेक्शन की क्या पावर है, आरओसी की इंक्वायरी की क्या पावर है, इंक्वायरी एंड इंस्पेक्शन ऑफ द डॉक्यूमेंट की आरओसी की पावर क्या है। ये सेक्शन आज तक इस चीज की बात करता था, बट ये सेक्शन कभी एलएलपी में नहीं था। तो प्रैक्टिकली स्पीकिंग आउट ऑफ द बॉक्स वन थिंग आई वांट टू टेल यू कि प्रैक्टिकली स्पीकिंग ठीक आरओसी के पास सारी पावर होती है, बट कंपनीज एक्ट में ना आरओसी एलएलपी एक्ट में आरओसी के पास इंस्पेक्शन इंक्वायरी की पावर तक नहीं थी। मतलब मिनिस्ट्री ने इंस्पेक्शन इंक्वायरी की भी पूरी पावर एलएलपी को नहीं दी थी। जो पावर अब एलएलपी में आरओसी के पास आई है बाय दिस अमेंडमेंट, तो बाय दिस अमेंडमेंट अब एलएलपी में भी ये पावर आरओसी के पास आ गई है। तो अब ये कहना कोई गलत नहीं होगा कि आने वाले दिनों में यू विल सी कि आज तक तो सिर्फ कंपनीज एक्ट में नोटिस इशू होते हैं, आज तक सिर्फ कंपनीज एक्ट में ही हम बोल सकते हैं नोटिस इशू होते हैं, कंपनीज एक्ट में ही अगर आपने देखा होगा कि आरओसी इंक्वायरी कर रहा है, इंस्पेक्शन कर रहा है। बट अब आपको देखने को मिलेगा कि कंपनीज एक्ट के साथ साथ एलएलपीज में भी आरओसी नोटिस इशू करना स्टार्ट करेंगे, इंक्वायरी करना स्टार्ट करेंगे। दे विल कॉल द बुक्स, दे विल कॉल द books and accounts are the document of the LLPs also. आज तक नहीं किया, क्यों नहीं किया? बिकॉज क्लियर कट प्रोविजन नहीं थे, क्लियर कट प्रोविजन ही नहीं थे मिनिस्ट्री ऑफ कॉर्पोरेट आरओसी के पास। बट अब आरओसी के पास क्लियर कट प्रोविजन है, आरओसी के पास क्लियर कट देयर आर द ऑप्शंस है। तो जब क्लियर कट ऑप्शंस है, क्लियर कट प्रोविजंस है, तो नाउ यू विल सी कि देयर आर द लॉट ऑफ इश्यूज विल बी इशूड अंडर द एलएलपी एक्ट, lot of we can say inquiry inspection will be conducted against the LLPs also under the LLPs Act. So now this is the 5th and 6th section of the Companies Act which is now applicable on the LLPs. अब इसके बाद बात करते हैं 7th section revival of companies. अगर मैं आप सभी से एक सिंपल क्वेश्चन पूछूं, कंपनीज एक्ट में आप सभी ने रिवाइवल के प्रोविजन देखे हैं, रिवाइवल की पावर्स देखी है, रिवाइवल का काम किया है। अगर मैं आपसे बात करूं कि एलएलपी एक्ट में रिवाइवल की पावर किसके पास है, एलएलपी एक्ट में रिवाइवल कौन कर सकता है, व्हाट विल बी योर आंसर? हु इज हैविंग द अथॉरिटी, हु इज हैविंग द अथॉरिटी टू फॉर द रिवाइवल अंडर द एलएलपी, हु इज हैविंग द अथॉरिटी फॉर द रिवाइवल अंडर द एलएलपी एक्ट? कैन एनीवन आंसर कि एलएलपी एक्ट में अगर आपकी कोई एलएलपी डिफेक्ट हो गई है, या आपकी कोई एलएलपी डिफेक्ट हो गई है, या फिर आपकी एलएलपी बोल सकते हो कि स्ट्रक ऑफ ही हो गई है मिनिस्ट्री से, तो उसको रिवाइव करने का क्या प्रोसेस है, रिवाइव करने का क्या प्रोविजन है आपके पास? कैन एनीवन टेल मी कि पावर किसके पास है? जस्ट अ सिंपल थिंग कि पावर किसके पास है? कैन एनीवन रिवर्ट कि एलएलपी एक्ट में अगर आपकी एलएलपी स्ट्रक ऑफ हो जाती है, डिफेक्ट हो जाती है, तो एलएलपी एक्ट में रिवाइवल की पावर किसके पास है? हु कैन आस्क द रिवाइवल?
Deshi, I'm taking a wild guess. NCLT.
एनसीएलटी, राइट? तो जैसे हम कंपनीज एक्ट में देखो रिवाइवल की बात करते हैं, तो हम बोलते हैं कि कंपनीज एक्ट में रिवाइवल की क्लियर कट पावर एनसीएलटी के पास है, तो दैट शुड सेम विद द एलएलपी एक्ट। बट अब ये अमेंडमेंट क्यों आए हैं? अमेंडमेंट के पीछे रीजन क्या है कि इतनी डिफिकल्टीज थी ना। आप प्रैक्टिकली स्पीकिंग 2008 में एलएलपी एक्ट आया था, दिस इज 2022, आज तक एलएलपी एक्ट में कोई रिवाइवल के प्रोविजन ही नहीं थे। देयर वाज नो सच प्रोविजन कि आप किसी के पास भी अगर रिवाइवल की एप्लीकेशन फाइल करते आज तक, तो नो वन हैविंग द अथॉरिटी फॉर द रिवाइवल अप्रूवल, आरओसी, आरडी, एनसीएलटी, एमसीए, किसी के पास पावर ही नहीं थी। So this is the first time they are coming with the provision, because I have personally seen in the Delhi ROC, as I belong to the Delhi, I have personally seen in the Delhi ROC कि so many application has been filed by the LLPs in the ROC कि हमारी LLP डिफेक्ट हो गई है, प्लीज रिवाइव आवर LLP, बट कोई प्रोविजन ही नहीं है। वो एप्लीकेशन एज इट इज ROC के पास पड़ी है, बिकॉज जब पावर नहीं है तो ना तो रिजेक्ट करेंगे ना अप्रूव करेंगे, दैट विल बी एज इट इज देयर। सो फाइनली by this notification of applicable of the 8th section of the Companies Act on the LLP on the 12th February 2022, 12th February 2022, ministry came with this notification and they said, now section 252, now section 252 will be applicable on the LLPs also. Now section 252 will be applicable on the LLPs. तो अगर सेक्शन 252 एलएलपी पे एप्लीकेबल होता है, तो इसका एक बहुत सिंपल मीनिंग है कि जो रिवाइवल के प्रोविजन कंपनीज एक्ट में कंपनी पे लगते हैं, एग्जैक्ट सेम रिवाइवल के प्रोविजन अब एलएलपी एक्ट में भी लगेंगे। तो जैसा अभी इन्होंने बोला सर ने कि कंपनीज एक्ट में तो हम एनसीएलटी के पास जाते हैं, तो वो सेम थिंग अब एलएलपी एक्ट में भी आपको एनसीएलटी को अप्रोच करना पड़ेगा फॉर द रिवाइवल। अब आप एलएलपी को एनसीएलटी को अप्रोच करोगे, वेदर इट इज अ एलएलपी, वेदर इट इज अ कंपनी। तो अब इसका इम्पैक्ट क्या आया कि अगर अब आज की डेट में आपकी कोई एलएलपी डिफेक्ट है, कोई स्ट्राइक ऑफ है, तो यू कैन इजिली गो टू द एनसीएलटी एंड फाइल अ पिटीशन विद द एनसीएलटी। देन एज जैसे कंपनीज एक्ट में एनसीएलटी हियरिंग्स करता था, वैसे ही एनसीएलटी हियरिंग्स करेगा, और हियरिंग्स के बाद दे विल डिसाइड अबाउट द सेम। So this is the one of the very important provision of the LLP Act. Section 439, offense to be non-cognizable. मिनिस्ट्री, आपको पता है कि मिनिस्ट्री ने लास्ट 2 ईयर से कंपनीज एक्ट और एलएलपी में एक ड्राइव स्टार्ट की हुई है, डिक्रिमिनलाइजेशन ऑफ ऑफेंसेस। डीक्रिमिनलाइजेशन ऑफ ऑफेंसेस की उन्होंने ड्राइव स्टार्ट की है। उस डीक्रिमिनलाइजेशन ऑफ ऑफेंसेस की ड्राइव के अकॉर्डिंग उन्होंने क्या किया है, उस ड्राइव में दे हैव डन द वन थिंग कि उस ड्राइव के अकॉर्डिंग कंपनीज एक्ट के ऐसे बहुत सारे सेक्शन जिनमें पहले आप बोल सकते हो कि क्रिमिनल पेनल्टीज थी, जिनमें प्रोसिक्यूशन थी, अब उन सेक्शन में प्रोसिक्यूशन और क्रिमिनल पेनल्टीज तो मिनिस्ट्री ने रिमूव कर दिया, दे हैव रिमूव दैट। और पर्पस क्या है कि आप देखो ना, आप एक कंपनीज एक्ट के किसी सेक्शन का नॉन कंप्लायंस करते हो या एलएलपी के किसी सेक्शन का आप नॉन कंप्लायंस करते हो, उस नॉन कंप्लायंस के लिए आपको जेल में डाल दे, ये तो कोई जस्टिफाइड रीजन नहीं होगा, या उसके लिए आपके ऊपर क्रिमिनल प्रोसिक्यूशन लगा दे, दिस इज नॉट जस्टिफाइड। तो एलएलपी में, कंपनीज एक्ट में आपने कोई नॉन कंप्लायंस किया है, कोई फॉर्म डिले कर दिया है, कोई और चीज किया है, तो आप उसके लिए पनिशमेंट दो, आप उसके लिए फाइन लगाओ, पेनल्टीज लगाओ, सब चीजें लगाओ, बट आप उसके लिए जेल नहीं कर सकते हो। तो दे स्टार्टेड अ ड्राइव फॉर द नॉन कॉग्निजेबल, वी कैन से डीक्रिमिनलाइजेशन ऑफ द ऑफेंसेस। तो डीक्रिमिनलाइजेशन ऑफ ऑफेंसेस की ड्राइव उन्होंने स्टार्ट की मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर ने। उसी ड्राइव का एक रीजन है कि एलएलपी अमेंडमेंट एक्ट का भी उनका एक पर्पज है, डीक्रिमिनलाइजेशन ऑफ ऑफेंसेस। तो इसलिए इन्होंने जो नॉन कॉग्निजेबल ऑफेंसेस वाला सेक्शन है कंपनीज एक्ट का, उसके भी कुछ प्रोविजन एलएलपी पे इंप्लीमेंट किए हैं। So these are the 8 provision of the LLP Act. So these are the 8 provision of the Companies Act which is now applicable on the LLP Act. Are these clear? First we should focus on this because आज का हमारा टारगेट यही है। तो किसी का कोई इस पे क्वेश्चन, कोई डाउट? Anyone have any questions?
I would request if anyone has any question, then they might unmute themselves and.
I feel कि these provisions are clear.
Yes, Devesh.
So I will take 10 more minutes. तो मैं आपको थोड़ा सा और ब्रीफ कर देता हूँ। अभी तो हमने सिर्फ जो हमारा आज का मेन टॉपिक था कि एलएलपी एक्ट के ऐसे कौन से प्रोविजन है, तो कंपनीज एक्ट के ऐसे कौन से प्रोविजन है जो एलएलपी पे एप्लीकेबल है, वो तो हमने डिस्कस कर लिया। सेकंड में थोड़ा सा आपको ब्रीफ कर देता हूँ एलएलपी अमेंडमेंट एक्ट के बारे में। सो आई विल टेक 10 मोर मिनट्स। इसके बाद किसी का कोई डाउट हो तो यू कैन आस्क मी द डाउट। फर्स्ट थिंग इज दैट दे कम अप विद अ न्यू कंसेप्ट ऑफ द स्मॉल एलएलपी। स्मॉल एलएलपी का कंसेप्ट अभी तक एलएलपी एक्ट में नहीं था, बट फर्स्ट टाइम इंट्रोड्यूस हुआ है। They simply mention small LLP means a LLP whose contribution does not exceed 25 lakh when whose we can say turnover does not exceed 40 lakh। तो अगर आपकी कैपिटल 25 लाख से नीचे है या 25 लाख या 25 लाख से नीचे है और आपकी टर्नओवर 25 लाख से नीचे है, सॉरी 40 लाख या उससे नीचे है, देन यू विल बी कंसीडर एज अ स्मॉल एलएलपी। तो अभी तक स्मॉल एलएलपी का कंसेप्ट नहीं था, कंपनीज एक्ट में सिर्फ कंसेप्ट था स्मॉल कंपनीज का, बट नाउ वी आर हैविंग द कंसेप्ट ऑफ द स्मॉल एलएलपीज आल्सो। अब यहाँ पे एक क्वेश्चन आता है, जैसे कंपनीज एक्ट में जब हम स्मॉल एलएलपी और नॉन स्मॉल एलएलपी की बात करते हैं ना, तो वहां पे बहुत सारे कंप्लायंस डिफरेंस है। स्मॉल एलएलपी और नॉन स्मॉल एलएलपी में बहुत सारे कंप्लायंस, कंपनी और नॉन स्मॉल कंपनी में बहुत डिफरेंस है। तो यहाँ पे क्वेश्चन आता है कि स्मॉल एलएलपी और नॉन स्मॉल एलएलपी में भी बहुत सारे डिफरेंसेस है, क्या यहाँ स्मॉल एलएलपी को भी बहुत सारे कंप्लायंसेस के बेनिफिट मिलेंगे? तो आई मस्ट से नो। द रीजन इज दैट आप लोगों को पता है ऑलरेडी एलएलपीज में बहुत कम कंप्लायंस होते हैं। ऑलरेडी एलएलपीज में रेयर ही कंप्लायंस होते हैं, ज्यादा कंप्लायंस नहीं होते हैं। तो अगर रेयर कंप्लायंसेस में भी हम सोचे कि और कम करने का, तो मिनिस्ट्री का बिल्कुल भी पर्पस नहीं है कि और रेयर कंप्लायंसेस को और कम करने का। तो अगर आप मेरे से पूछते हो कि स्मॉल एलएलपी और नॉन स्मॉल एलएलपी में क्या डिफरेंस है, तो मेरे अकॉर्डिंग स्मॉल एलएलपी और नॉन स्मॉल एलएलपी में एक ही डिफरेंस है जो पहले भी था। वो ये है कि पहले भी जब हम ऑडिट की बात करते थे तो सभी एलएलपी पे ना ऑडिट नहीं लगता था। एलएलपी एक्ट की बात करूं तो सभी एलएलपी पे पहले भी ऑडिट नहीं लगता था, ऑडिट लगता था कुछ एक लिमिट के बाद। और वो लिमिट एग्जैक्ट वही लिमिट है जो आज की डेट में हम स्मॉल एलएलपी की बात करते हैं। तो मिनिस्ट्री ने उस लिमिट को कन्वर्ट करके नया नाम दे दिया है स्मॉल एलएलपी। तो अगर स्मॉल एलएलपी और नॉन स्मॉल एलएलपी की कोई मेरे से बात करता तो मैं एक ही चीज बोलूंगा, स्मॉल एलएलपी और नॉन स्मॉल एलएलपी में ये कंप्लायंस डिफरेंस है कि स्मॉल एलएलपी के ऑडिट करवाने की जरूरत नहीं है, उसकी बैलेंस शीट डेजिग्नेटेड पार्टनर खुद साइन कर सकते हैं, पर नॉन स्मॉल एलएलपी की ऑडिट करवाना मैंडेटरी है। दिस इज द फर्स्ट थिंग। मैं मेजर अमेंडमेंट ले लेता हूँ। हाँ, चेंज ऑफ द नेम ऑफ द लिमिटेड लाइबिलिटी पार्टनरशिप, छोटा सा सेक्शन है बट इंपॉर्टेंट है। ये सेक्शन बोलता है कि अगर आपने कोई एलएलपी इनकॉर्पोरेट की है या आपने अपनी किसी एलएलपी का नेम चेंज किया है, ध्यान से सुनिएगा, आपने कोई एलएलपी इनकॉर्पोरेट की है या आपने कोई एलएलपी का नाम चेंज किया है, उस इनकॉर्पोरेशन में या उस चेंज ऑफ नेम में ऐसा कोई वर्ड आपने अपने नाम में यूज किया है जो किसी और का ट्रेडमार्क है, उस इनकॉर्पोरेशन में या चेंज ऑफ नेम ने ऐसा कोई भी वर्ड अगर आपने यूज किया है जो किसी और का ट्रेडमार्क है, तो ट्रेडमार्क ओनर के पास राइट है कि विद इन 3 years फ्रॉम द इनकॉर्पोरेशन ऑफ चेंज ऑफ नेम वट एवर इज द सिचुएशन, वो आरडी में कंप्लेंट फाइल कर सकता है। ये नया प्रोविजन है, आप भी अपने क्लाइंट्स को गाइड कर सकते हो। अगर आपके क्लाइंट का ट्रेडमार्क है और किसी ने उसको यूज किया, किसी और ने उस नाम की कंपनी बनाई, किसी और ने उस नाम की एलएलपी बनाई, तो 3 साल के अंदर अंदर आप आरडी को, रीजनल डायरेक्टर को कंप्लेंट फाइल कर सकते हो। दिस इज द फर्स्ट थिंग। अब सेकंड थिंग क्या है, आरडी को आपने कंप्लेंट फाइल की, आरडी उस एलएलपी को नोटिस इशू करेगा। अब यहाँ पे एक मेन इंपॉर्टेंट चीज क्या है, अब इन्होंने एक अमेंडमेंट यहां किया है। दे सेड कि जब आरडी उस एलएलपी को नोटिस इशू करेगा अपना नेम चेंज करने के लिए, क्योंकि उस नेम में जो वर्ड यूज कर रहे हो किसी और का ट्रेडमार्क है, उस नोटिस इशू होने के 3 महीने के अंदर अंदर एलएलपी को अपना नाम चेंज करना है। 3 महीने के अंदर अंदर अगर एलएलपी 3 महीने के अंदर चेंज नहीं करती नाम, तो दे हैव टू फेस द कॉन्सिक्वेंसेस। नाउ एनीवन गेस कि कॉन्सिक्वेंसेस हो क्या सकते हैं? जनरली नॉन कंप्लायंसेस के लिए क्या कॉन्सिक्वेंसेस होते हैं? जनरली यही होता है, पेनल्टी लगा देंगे, फाइन लगा देंगे। नॉन कॉन्सिक्वेंस, नॉन वी कैन से कंप्लायंस का यही होता है, बट यहाँ इन्होंने कुछ चेंज किया। यहाँ इन्होंने ऐसा कुछ नहीं लिखा कि अगर आप 3 महीने में नहीं नाम चेंज करते तो हम इतनी पेनल्टी लगाएंगे या इतना फाइन लगाएंगे। दे सेड कि अगर आप 3 महीने में अपना नाम नहीं चेंज करते हो तो आरडी itself will change your name. This is a big thing. अगर आप 3 महीने में आप नाम चेंज नहीं करते हो तो आरडी खुद आपका नाम चेंज कर देगा। आरडी itself will change your name. अब यह क्वेश्चन आता है, मेरा ऑलरेडी जो नेम था वो था एबीसी सॉल्यूशन प्राइवेट लिमिटेड, तो आरडी क्या चेंज करके मुझे एबीसी वर्ड की जगह कोई XYZ देगा, कोई PQR देगा, क्या देगा? आरडी क्या मतलब पहले रिसर्च करेगा कि आपको क्या नेम सूट करता है, आपको क्या नेम देना चाहिए, और देन उस रिसर्च के बेस पे आरडी हमें नेम देगा? तो ऐसा बिल्कुल भी नहीं है। आरडी कोई रिसर्च नहीं करने वाला, आरडी कोई रिसर्च नहीं करने वाला, तो ये काम आरडी क्यों करेगा? तो यहाँ पे आरडी एक बहुत सिंपल चीज करेगा, ध्यान से सुनना, बहुत इंपॉर्टेंट चीज है। दिस सेक्शन सेड कि अगर आपने 3 महीने में नोटिस के नेम चेंज नहीं किया तो आरडी विल चेंज योर नेम। और अगर आपका पुराना नेम था एबीसी सॉल्यूशन एलएलपी, अगर आपका पुराना नेम था एबीसी सॉल्यूशन एलएलपी, तो योर न्यू नेम विल बी एबीसी सॉल्यूशन एलएलपी नॉट कंप्लाइड विद द ऑर्डर ऑफ द रीजनल डायरेक्टर। देखा, यहाँ मिनिस्ट्री ने इस बार पेनल्टी और फाइन्स को इंपॉर्टेंस ना देते हुए कंप्लायंस को इंपॉर्टेंस दिया। तो दे सेड कि या तो आप नेम चेंज करो, आप नहीं चेंज करते तो हम अपने आप करेंगे, और हम आपके नेम के साथ में लिख देंगे कि यू हैव नॉट कंप्लाइड विद द ऑर्डर ऑफ द रीजनल डायरेक्टर। एंड वन मोर थिंग दे सेड, जो ये न्यू नेम होगा ये न्यू नेम आपको मेंशन करना होगा अपने सभी लेटर हेड पे, नोटिस पे, डॉक्यूमेंट पे, इनवॉइसेस पे, एवरीवेयर यू हैव टू मेंशन दिस न्यू नेम. So this is the one of the very most important amendment under the LLP Act. One thing, अब मैं थोड़ा सा स्पीड में लेता हूँ, just 5 minutes more I will take. Accounting and auditing standard. अभी तक LLP के लिए कोई prescribed, properly prescribed accounting या auditing standard नहीं है. So now ministry are coming with the NAFRA will consult with the ICAI. NAFRA in consultation with the ICAI will come up with the we can say accounting and auditing standard for the LLPs also. Compounding of offense. Compounding of offense का जो पुराना सेक्शन था 39 वो सब्स्टिट्यूट करके नया सेक्शन आ गया है. नए सेक्शन में क्लियर कट पावर दी गई है आरडी को. ऑल टाइप ऑफ कंपाउंडिंग अंडर एलएलपी एक्ट इज द पावर ऑफ द आरडी. कंपनीज एक्ट में तो क्या होता है, अगर 25 लाख तक की कंपाउंडिंग है तो आरडी करेगा, 25 लाख से ज्यादा है तो एनसीएलटी करेगा. पर यहाँ पे ऐसा बिल्कुल भी नहीं है. यहाँ ऑल द कंपाउंडिंग शैल बी डन बाय द आरडी इटसेल्फ. एस्टेब्लिशमेंट ऑफ द स्पेशल कोर्ट. एलएलपी एक्ट में अभी तक ना कोई स्पेशल कोर्ट का प्रोविजन नहीं था. तो नाउ मिनिस्ट्री इज कमिंग विद द स्पेशल कोर्ट प्रोविजन अंडर द एलएलपी आल्सो. तो स्पेशल कोर्ट के प्रोविजंस इन्होंने इंट्रोड्यूस कर दिए हैं और स्पेशल कोर्ट डेजिग्नेट करना स्टार्ट करने का प्रोसेस भी स्टार्ट हो गया है. तो सूनर वी विल से कि विद इन अ कपल ऑफ मंथ्स नाउ द स्पेशल कोर्ट्स अंडर द एलएलपी विल प्रैक्टिकली वर्किंग. दिस इज वेरी इंपॉर्टेंट थिंग. मिनिस्ट्री ने क्या किया है, कंपनीज एक्ट में एलएलपी एक्ट में अमेंडमेंट की है, उसमें से सबसे अच्छा अमेंडमेंट मैं अब इस स्लाइड में डिस्कस करने जाऊंगा. जो सबसे बेस्ट अमेंडमेंट किया है वो एलएलपीज में एडिशनल फीसिस को रिड्यूस करके किया है. आज तक एलएलपी एक्ट में अगर हम बात करते हैं ना तो एडिशनल फीस लगती थी. कोई भी एलएलपी का फॉर्म अगर आप डिले कर दोगे ना फाइल करने में तो ड्यू डेट के नेक्स्ट डेट से 100 रुपीज की एडिशनल फीस लगती थी. और सबसे बड़ी बात, इस 100 रुपीज की एडिशनल फीस की कोई अपर कैप नहीं थी. ये 100 रुपीज की एडिशनल फीस एक बार लगना स्टार्ट होगी तो जब तक आप फॉर्म नहीं फाइल करोगे लगती रहेगी. 1 साल नहीं फाइल करोगे तो 365 इंटू 100, 2 साल नहीं फाइल करोगे 730 इंटू 100, तो वो बढ़ती जाएगी. मतलब 36,000, 73,000, लाख तक पहुंच जाएगी. मैंने अपनी लाइफ में एक बार एक एलएलपी का फॉर्म, एलएलपी 3 फॉर्म 3.5 लाख रुपए फीस देके फाइल किया था क्योंकि वो बहुत ज्यादा डिलेड था. क्योंकि यहाँ मैक्सिमम लिमिट ही नहीं है तो बहुत बड़ा इशू था ये सभी के लिए. अब इस इशू को रिजोल्व कर दिया मिनिस्ट्री ने. एलएलपी में नया एडिशनल फीसिस का पूरा स्ट्रक्चर मिनिस्ट्री ने इंट्रोड्यूस कर दिया. तो अब एलएलपी में जो एडिशनल फीसिस लगेगी वो एडिशनल फीसिस इस क्राइटेरिया के अकॉर्डिंग लगेगी. अगर आप स्मॉल एलएलपी है, नॉन स्मॉल, दोनों के लिए अलग अलग है. अगर आप स्मॉल एलएलपी है, आपने कोई फॉर्म डिले कर दिया फाइल करने के लिए, अप टू 15 डेज आप पे जो एडिशनल फीस लगेगी 1 टाइम, अप टू 30 डेज 2 टाइम. पहले अप टू 30 डेज लगती थी 30 इंटू 100 3000. अब लगेगी ओनली 2 टाइम. अगर 50 रुपए फीस है फॉर्म की नॉर्मल तो 2 टाइम मतलब 100 रुपीज एडिशनल फीस. तो आप देख सकते हो कितना ड्रास्टिकली एडिशनल फीस को रिड्यूस किया है. 30 टू 60 डेज 4 टाइम, 60 टू 90 डेज 6 टाइम और 360 डेज तक 15 टाइम. आपके फॉर्म की फीस अगर 1500 रुपए है तो 15 टाइम मतलब 1500 रुपए एडिशनल फीस. और पहले ये कितनी पे करनी पड़ती थी 360 दिन के लिए? 360 इंटू 100 36,000 पहले हमें पे करनी पड़ती थी. तो जो फीस पहले 36,000 तक पे करनी पड़ती थी अब वो हमें 1000 में ही ऑलमोस्ट कंप्लीट हो रही है. तो वी कैन से कि दिस इज अ वेरी ग्रेट मूव बाय द मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स. एंड दे सेड कि अब ये मैक्सिमम फीस का भी क्राइटेरिया लेके आ रहे हैं. 360 डेज तक 15 टाइम, 360 डेज के बाद 2 बैलेंस इन्होंने 2 अलग अलग क्राइटेरिया कर दिए हैं. एक क्राइटेरिया कर दिया है फॉर्म 8 और 11 जो हमारा एनुअल रिटर्न और बैलेंस शीट होता है. एक कर दिया है अदर फॉर्म. 360 डेज के बाद फॉर्म 8 और 11 पे जो आपकी अदर देन फॉर्म 8 और 11 पे जो एडिशनल फीस लगेगी वो मैक्सिमम 25 टाइम, 25 टाइम इज द मैक्सिमम लिमिट. तो मतलब एलएलपी के फॉर्म पे 50 रुपए 100 रुपए की तो फीस होती है. 50 रुपए वाले का मैक्सिमम 25 कर भी दोगे तो 1250 रुपए. और पहले जैसा कि मैंने बताया लाखों में भी पे करनी पड़ती थी. और LLP 8 और LLP 11 की बात करते हैं तो उसमें 360 डेज तक तो 15 टाइम और 361st डे से 15 टाइम प्लस 10 rupees per day. So we can say they have drastically reduced the additional fees under the LLP Act by this schedule. और नॉन स्मॉल LLP की बात करते हैं तो नॉन स्मॉल LLP में स्मॉल LLP से जस्ट डबल रखा है, जैसे अप टू 30 डेज 4 टाइम, अप टू 60 डेज 8 टाइम, 360 डेज तक 30 टाइम, 360 डेज तक स्मॉल में था 15 टाइम, यहाँ कर दिया 30 टाइम, और आफ्टर 360 डेज स्मॉल में था 25 टाइम और नॉन स्मॉल में है 50 टाइम, और फॉर्म 8 और 11 के लिए है 30 टाइम प्लस 20 rupees per day. So this is one of the great move and one of the drastic move we can say by the Ministry of Corporate Affairs by this LLP Amendment Act. तो इस LLP Amendment Act से एडिशनल फीसिंग बहुत रिड्यूस हो गई है और ये सेक्शन ऑलरेडी इंप्लीमेंट हो चुका है 1 अप्रैल 2022 से. अब यहाँ पे एक सभी का बहुत क्वेश्चन आता है कि ये अमेंडमेंट आया है 1 अप्रैल 2022 से. अब इससे पहले का कोई फॉर्म पेंडिंग है फाइलिंग के लिए, इस डेट से पहले का अगर कोई फॉर्म पेंडिंग है फाइलिंग के लिए तो उस पर एडिशनल फीस कितनी लगेगी? क्या उस पर नए क्राइटेरिया से एडिशनल फीस लगेगी या उस पर ओल्ड क्राइटेरिया से एडिशनल फीस लगेगी? व्हाट इज योर व्यू? क्या एडिशनल फीस लगनी चाहिए पुराने फॉर्म्स के लिए? जो फॉर्म इस डेट से पहले का था, क्या उस पे न्यू स्ट्रक्चर से एडिशनल फीस लगनी चाहिए या उस पे ओल्ड स्ट्रक्चर से एडिशनल फीस लगनी चाहिए? तो यहाँ मिनिस्ट्री ने एक बहुत अच्छा वी कैन से हमें ऑप्शन दिया है कि अगर हमारा कोई पुराना LLP का फॉर्म भी है, पुराने से मतलब चाहे 5-10 साल पुराना भी है ना, और उसको आज की डेट में फाइल करते हो तो न्यू स्ट्रक्चर उस पर लगेगा. तो मैक्सिमम टू मैक्सिमम जो एडिशनल फीस उस पर लग सकती है वो 25 टाइम इन केस ऑफ स्मॉल और 50 टाइम इन केस ऑफ नॉन स्मॉल. So this is, we can say, a very great move by the Ministry of Corporate Affairs by amendment under the LLP Amendment Act or by implementation of certain section of the Companies Act 2013 on the LLP Act. So this is all from my side in today's session. Now, if anyone have any question, any query, we can discuss on the same. Now, I will hand over the mic to the Ayush, please.
Yeah, Divesh.
Yes.
If anyone has any questions, I think Divesh, there are no questions.
Yeah, I think everything is clear to everyone.
No, you explained it very articulately and very clearly. I think there are no doubts in the mind of anyone.
Thank you so
I'd
much.
like to propose a formal vote of thanks, Divesh.
Yes.
I thank you for participating today in the two-day corporate law conclave organized by ACAE. I would like to offer you a small e-memento. And we'll be sending this across to you over email as well.
Thank you so much. Thank you, Ayush.
Thank you, Divesh, for the wonderful session we had today.
Thank you so much.
We are honored to have you on our platform.
My pleasure. Thank you so much.
Thank you, Divesh.
Okay.
Ramaswamy sir, I would like to welcome you on the platform, sir. Shall we begin with the third session? I'd like to welcome CS Ramaswamy Kalidas ji, who will be deliberating on liabilities of directors under Companies Act 2013 today. I will give a formal introduction. Although Ramaswamy sir does not require any introduction on the platform of ACAE. However, he is a fellow member of the Institute of Company Secretaries of India. He has done his MBA in finance from Jadavpur University, Kolkata. He has done his BCom honors from St. Xavier's College, Kolkata. He has more than 4 decades of experience in industry after starting professional career in the year 1978. He has worked in leading companies such as Ambuja Siemens. He has been a company secretary and senior VP for Reliance Power Limited from October 10 till June 2017. He has been a company secretary and head of compliance for ACC Limited from August 17 till December 2019 until superannuation. He is now in practice as a partner of a leading firm of practicing company secretaries. He was a visiting faculty in XLRI Jamshedpur, a premier management institute, taking courses on corporate law and governance. He has been an author of more than 100 articles on issues relating to corporate law, SEBI regulations, corporate governance, etc. Articles have been published in the Chartered Secretary, Taxman, SEBI, and corporate laws. Web portals such as Lawyers Club India, CAClubindia.com. He has been a regular speaker in seminars and conferences organized across the country by professional bodies. He was the member Secretarial Standards Board of the ICSI till 2020, Presently, he is a member of the Expert Committee on Secretarial Standards. He has authored many books, including Law and Practice Relating to Company Meetings, Law and Practice of Directors, Board Management, KMPs, etc., Specialist Editor to C.R. Datta on Company Law, Specialist Editor to M.C. Bhandari's Company Law Procedures, and Specialist Editor to A. Ramaiah on Company Law. With this, I will welcome C.S. Ramaswamy Kalidas ji to the forum and would request him to take the session forward. Sir, kindly unmute yourself, sir.
Yeah, good evening to all of you. It's a great pleasure for me to be addressing this August gathering, although it's virtual. In fact, it's ironic that for a Calcuttan, I'm having to address Calcuttans. I assume most of you are from listening in from Calcutta. It's ironic that I should be, as a Calcuttan, addressing you virtually, given the fact that I have lived 53 years of my life in Calcutta, and God willing, I shall have my resting place there. The urge is there for me to come back, but then the spirits are willing, but then the circumstances are not are compelling. So therefore, I'm having to carry on in Bombay. So it's always a pleasure to address your own association, because I happen to be, perhaps many people may not be aware, I'm a member of your association, and I have very large number of friends with whom I have interacted personally, professionally, etc. Right. Having said that, I would only one request I have is that, since as you can see, I'm not very computer savvy, I have given a presentation which I would like one of you to roll, whilst, because I'm not good at multitasking. I generally speak. So please roll the slides as we go along, and then what I will do is that whatever questions you have, you can park it in the chat box, and then at the end of the session, I shall take all your questions. But let's not have questions to interrupt the conversation, because firstly, there is a tendency for people to not to unmute, and which kind of disturbs the flow of thought. So I would rather prefer that all questions are collected in the chat box, and then I can answer them one after the other. And I can assure you that I shall leave no question unanswered. Having said that, thanks once again very much, and let us hope that, I would, sort of preface my discussion by saying that the topic that I have chosen to articulate on is very large by itself, and it gives, there is a huge amount of effort involved in trying to capsule it in the duration of an hour. So if I'm missing out on certain important issues, it's not because I don't want to articulate on them, but basically because of the premium that is available insofar as the time is concerned. Right, thanks. Let's go rolling, please. I have a small presentation which you can share. All the participants you can distribute it to them. Yeah. Liabilities of directors. I mean, this is a matter of great concern for those that are aspiring to be directors, and therefore one needs to know to what extent one is going to be entrenched in terms of obligations that are thrust under the law. So therefore, I thought that it would be important for us to understand the nuances of the law on this subject. Next slide, please. Next. Next slide.
I've already changed the slides. Is it?
Yeah, but it's not appearing on my screen. It's not appearing on my screen.
Is it appearing now?
No, it isn't.
Just 1 second.
Yes. Firstly, before we dig deep into the subject proper, I thought that we must understand a very important change in the definition of a director, which has emerged under the Companies Act as opposed to the old Act. The director under Section 2, subsection 34, the definition provided in the present Act is prima facie restrictive and exhaustive, in the sense that it says a director means a director who's been appointed to the board of the company. So therefore, it basically rests on the premise that whomsoever is considered as a director has to be appointed as a director to the board of the company. So therefore, you have to be, if you have to be considered as a director, you have to be a de jure director, in the sense that you have to be appointed as a director under the law. As opposed to that, under the previous Act, the definition was very inclusive, and director included a person functioning as a director by whatever name called. So even if you were not called a director under the previous Act, if you were performing with the authority of a director, you would be essentially considered as a director, notwithstanding that you do not have that designation of a director. Now, the difference in the law is very, very significant in the sense that, firstly, when a definition is a means definition, as you all know, when a term is defined as so-and-so means, it means it's a restrictive definition. When the definition is restrictive under the law, it means it is exhaustive, and the law does not permit you to import into the definition any term which is not used in the Act. On the other hand, like in the Income Tax Act, you define a person or income as income includes. Includes, when a definition is inclusive, it means that it is an extensive definition, and the amplitude of the section is not restricted only to the words that are used in the section. So like if you do not have the definition of income in the Income Tax Act to cover an activity of black marketing, it does not necessarily mean that the income that you generate out of black marketing is not income. So the term, when a definition is inclusive, it travels beyond the contours of the expressions used in the Act. Now, having said that, let's not immediately jump into the conclusion that the Companies Act is only talking about only that person who is appointed as a director and making him responsible as a director. Unfortunately, if that had remained so, a lot of problems would have been solved. But there are deeming provisions which come subsequently in the Act, by which even those persons who are not appointed to director as directors on the board could also be brought within the vortex of the definition. So, as I said, initially the reaction would be that the definition of a director is only de jure and not de facto. But on the other hand, as we will see, it is also de facto. When a section is de facto, what I'm trying to say is that, you may not have the position of a director. Like, for instance, Mr. Mukesh Ambani, in the context of Reliance Industries, would be having a say on every matter concerning the company. But it is impossible for him to be under law to be a director in all companies. So therefore, without his say-so, many decisions cannot be taken. And you can say that the board of the company with which he is not associated as a director could be considered to be acting or accustomed to act according to his directions. In which case, Mr. Ambani, notwithstanding the fact that he is not a director on the board, would be considered as a shadow director. And the concept of a shadow director is extremely important under the law, as even if you are not a director on the board, you can be implicated as a director if it is found circumstantially that the board of the company is accustomed to act according to your directions. In fact, but for the fact that a director has to be a natural person, because under the law, the company is a juridic person. It's a legal person, and it has to be therefore administered by natural persons. Otherwise, if you look at the situation of a holding company and a subsidiary company, as it normally happens, the holding company exercises the right of control over the activities of the subsidiary company. In many cases, the holding company has the right to nominate the majority of the directors in the subsidiary company. in which case the holding company would also be considered as a shadow director. But given the fact that the holding company is only a juridic person, you cannot hold the holding company as a director, and you will have to consider only those that are representing the holding company as shadow directors. And if you are a shadow director, the law says that because of your guidance and advice, if the company has done something which is wrong, you are liable to be prosecuted because the company has acted on the behest of your directions and you are dominating the board. So that way, if you look at the definition, subsequent portions in the law, if you look at the definition of an officer under section 259, and if you look at the definition of an officer who is in default under section 260, you will find that necessarily we have come back to the status quo ante, in the sense that the law recognizes, even the present law recognizes a director who's not on the board also to be a director. Next slide, please. Yeah, who's a director? Who's an officer under section 259? The term director is an officer includes under section 259 a director of the company. It also includes key managerial personnel. It also includes any person who, on his directions, the board is accustomed to act. However, there is an exception which is available. Suppose you are offering advice to the company in a professional capacity, say as a chartered accountant, as a lawyer, then you cannot be considered as a shadow director or as an officer insofar as the company is concerned. But if you are doing it without being in a professional capacity, in that case, you will be considered as a shadow director. And how a person is to be considered as a shadow director is a matter for the court to decide based on the circumstances. If the circumstantial evidence suggests that the board of the company is accustomed to act as per your directions, notwithstanding that you have not been appointed as a director in the board, you will be considered as a director. For all intents and purposes, you will be an officer. And if there is a default insofar as the company is concerned, you will also be considered as an officer who is in default under section 260. So eventually, you will find that notwithstanding that the definition of the director under the present law is restrictive, the change in the definition of director would apparently be only a matter of semantics. It's only a transposition of the language, but eventually the status quo has been restored. Next, please. Yeah, officer, as I said, is an inclusive term to cover empowered employees. In fact, the auditor of the company is also an officer. And if there is any default insofar as the audit function is concerned, he would be considered as an officer who is in default. And as I said, given the fact that the company is a juristic person, it has to have necessarily arms and legs, it has to have the brains, it has to have the support of natural persons. And therefore, the law provides that only a person who's a natural person could be a director. And there is a Supreme Court decision in Oriental Metal Processing Works which clarifies that only a natural person can be a director. Those of you who are old-timers will know that under the Companies Act of 1956, you had a concept of managing agency system where even the manager, even a company could act as the managing agent or the manager of another company. That concept is no longer there. So therefore, you, as a director, you are only supposed to be one who's a natural person. And the term officer in default under section 260 covers KMPs, full-time directors, or any person on whose advice the board is accustomed to act. So therefore, if there is any default of any function which has been, of which the responsibility has been entrusted on the officer, he shall be liable for the default. Right. Now, where it comes to default, as you know, there was a major amendment which was made under section 5 in the 1956 Act. There is no need for mens rea. Mens rea, as you know, is mala fide. And if there is an act which has been committed, which is erroneous under the provisions of law, it's not always necessary that mala fide should be proved. And when does the responsibility take place where it comes to any default? Where the director is concerned, the default should happen during the tenure of his appointment. Please understand that if I am appointed as a director today, in that case, all the acts that happen in the company as from today until the day I'm in the company will be, within the ambit of my responsibility, and I shall be responsible for any default. Of course, there are exceptions which we shall discuss. Now, please understand that when we are talking about an officer who is in default, we are only considering offenses which are, or defaults which are under the Companies Act. We are not covering other laws, economic laws, SEBI, FEMA, and what have you, or income tax law, right? Next, please. Now, what are the responsibilities of the directors? You see, this again is another, there is a semantic change insofar as the definition of the board is concerned. The board under the new act, as opposed to the old act, has been defined to be a collective body of persons acting as a board of directors. So the emphasis here is on collective responsibility. On the other hand, in the old act, the expression collective was conspicuous by its absence, right? So therefore, unless responsibility has been specifically identified with a particular director, in the absence of any specific fixation of responsibility or accountability, all the directors of the company are responsible where responsibility has not been assigned to anyone specifically. And there is a decision in Registrar of Companies versus Southern Machinery Works Limited. Now, in the event that a director has resigned before the commission of the event, what happens? And if there is a default which has happened after he has resigned, then in that case, the director has no liability. Now, the question which is very important is, when does resignation take place? When does the resignation of a director take place under law or effectuated under the law? Now, there is a dichotomy in the law between section 165 and 168 on the point of resignation. Now, section 165 is a section which says that a director can be on the board of a certain number of companies only. He can be on the board of at least of a maximum of 10 companies. Now, in this section, it says that if a director is having to resign by virtue of the fact that he is associated with more than the maximum number of companies, in that case, he can submit his resignation by submitting the letter to the company, and that's about it. In fact, under section 165, the resignation is supposed to take effect if the letter of resignation has been sent to the company. On the other hand, where it comes to section 168, which is a specific section which deals with resignation, 168 clearly says that a resignation of a director shall take effect only after the letter announcing his intention to resign has been received by the company and taken on record. So it's not good enough, as stated in section 165, if I resign as a director, but it is important also under section 168 that the resignation shall be taken into effect. Now, you know, as per the rules of statutory interpretation, if there is a dichotomy, if there is a conflict between a general provision and a specific provision, then the specific provision will invariably prevail. Section 168 is a specific provision which speaks about resignation of a director, and therefore the anomaly that you've noticed in comparison to 165 shall not stand the test of law, and the resignation shall be effective upon the board taking note of the resignation. That does not mean necessarily that the board has to accept the resignation. Please understand, unless the terms of the appointment of the director provide that the resignation will be effective only upon acceptance, that it will be effective, the resignation can be a unilateral act. In fact, in the very, very old English decision, Glossop versus Glossop, it was held that the director is absolutely under no obligation to continue as one, and he can choose to resign his position anytime he desires. Having said that, what would be the position of resignation where it comes to persons holding executive positions like a managing director or a whole-time director? Now, here the status is slightly different because the whole-time director or the managing director is discharging certain responsibilities, executive responsibilities, and therefore it is important that the board is not taken by surprise, and it is therefore necessary that the board should accept his resignation given the fact that it has to find a successor. So unless it is a case involving an executive director, the resignation of a director takes effect once the resignation is taken note of by the board. Next. Why are we talking about legal liabilities where the director is concerned? You see, this basically stems from the fact that the company is a very, very unique form of enterprise. The company is the only form of enterprise where the ownership and control are separated. The company is actually a juridic person. In fact, as Lord Denning said, a company can be exterminated only through the process of law. Not even a hydrogen bomb, he said, can, in Daimler Corporation, he described that not even a hydrogen bomb can destroy a company. So you can exterminate a company only through the process of law. Now, given the fact that the company is a juridic person which can own property, which can owe a liability, which can sue a person, which can be sued, you obviously will have to find a natural person with whom the responsibility begins and ends. So that is exactly why the company form, the law, the corporate law provides that the board, the shareholders are supposed to be the owners of the company in terms of the capital. They are not the owners of the company's assets. The assets continue to be owned by the company. They are the owners of the capital. And given the fact that they do not have the wherewithal, they do not have the ability to run the company, they consider it their responsibility to report confidence on a certain body of persons called the directors, who they think will be able to clear the company out of the choppy waters of an ecosystem. That is exactly why the directors are the representatives of the shareholders. And given the fact that they are the representatives of the shareholders, they owe a fiduciary responsibility. The fiduciary responsibility, mind you, is not to the shareholders necessarily. The fiduciary responsibility is with the company. So therefore, the status of the directors is somewhat analogous to trustees and agents. You know, under the Trust Act, when I'm appointed, there is, however, a difference. Under the Trust Act, if I'm appointed as a trustee to a trust, the property of the trust is actually bequeathed to me. And I am supposed to use the property in a manner which is subservient to the interests of the beneficiaries. Again, when I am appointed as an agent by a principal, then I am responsible for all the action that has been delegated to me. But the law doesn't operate that way insofar as the director is concerned, because the directors do not own the property. The company continues to be owned by the juridic person. And similarly, the directors cannot be held responsible only as agents. Otherwise, for everything, they would have to consult the shareholders. And as you know, under the law, there are several powers that are exercisable by the directors through powers which are endowed upon them under Section 179. And it's only for certain matters that they have to seek the approval of the shareholders post action, and in certain matters they have to seek the approval of the shareholders prior to taking action. So the separation of ownership and control is a very, very unique characteristic of a company, and that is exactly the reason why there has to be fixation of responsibility on these persons who are called directors, who owe it to the company to discharge their functions in a manner which is subservient to the interests of the company. I'm not saying that you have to cater to the interest of the shareholder, because today a company has several stakeholders. Its shareholder is only one of the stakeholders. So you have to discharge your responsibilities, fiduciary responsibilities, in a manner which is subservient to the interests of the entire fraternity of stakeholders. And the law has built beautifully some fetters over the directors' powers so that the directors do not abuse their authority under the law. Next. Whether the directors can be held responsible under the Companies Act for any economic offense, the answer is no. As I said, Section 260 only talks about officer in default for the purposes of the Companies Act. So if there is any offense under FEMA or the other, you cannot be held responsible under the Companies Act. And there is a decision of the Madras Flying Club on this. Next slide, please. What is the, we've talked about the expression liability, but I have not tried to explain what is liability. The term liability under law has several hues. There are several connotations to the term liability. One of the connotations is that it is an obligation. It's an obligation. It is an obligation. It is a duty. It is a duty to do. It is an obligation to do or not to do something. Now, the obligations are not necessarily financial. The obligations can be several others. I mean, financial obligation would be the liability to pay off the debts. The other could be an obligation to discharge a contract or to execute a contract. So, and secondly, liabilities can also be civil liabilities where there is an infraction of law and the accountability and responsibility is enforceable by civil legal authorities, and the non-compliances of civil offenses will attract punishment by way of fine. On the other hand, there are criminal liabilities where there has to be prosecution through criminal proceedings. And as I said, the director being the natural person, and you cannot obviously put a company into prison. And that is exactly why you have the concept of a vicarious liability where the directors are concerned. What is a vicarious liability? Vicarious liability is a situation where the offense has been committed by somebody, but the responsibility for the offense has to be taken by somebody else. Like, for instance, if a company has violated the provisions of the FEMA, now the offender is the company. But as I said, given the fact that the company is not a natural person, the responsibility, the vicarious responsibility for that liability should fall on the directors who are responsible. In fact, the Supreme Court has spoken in, which we will discuss a little later, the Supreme Court has spoken about vicarious liability in the context of Airtel, and they say that those that are in authority, or they have used the theory of alter ego, whereby only those persons who are in positions of authority can be held responsible for criminal acts. Next. Now, what are the actions that give rise to liabilities? Liabilities for the directors can arise due to a breach of fiduciary duties. As I said, fiduciary duties are to the company, and if there is any breach in fiduciary duties, we will look at situations from jurisprudence where the director has been held responsible for non-compliance with fiduciary duties. Or alternatively, if the company is committing any act which is ultra-virus the company. Ultra-virus the act, ultra-virus the company. Ultra-virus is something beyond capacity. So if you're doing an act which is not allowed under the law or which is not allowed under the memorandum and articles of association, you are doing an ultra-virus act. There can be an act which is ultra-virus the memorandum, but intra-virus the company, which can be rectified by sanction by the shareholders in a meeting. Intra-virus the company means that, see, suppose your articles say that without the authority of the shareholders, you cannot increase the capital. Now, you've done something which is ultra-virus the articles of association and the memorandum. But this can be rectified through seeking the approval of the shareholders. So you can have acts which are ultra-virus the articles and the memorandum, but intra-virus the act. On the other hand, there are acts which are ultra-virus the act, which cannot be rectified by any subsequent action. Again, a director is responsible for any acts which are supposed to be negligent. Now, what constitutes negligence is also something which we will look at. And then finally, the action takes place when there is any action which is malafide, where you have an axe to grind, you have an agenda which is in conflict with the agenda of the company, and you are doing something for the purposes of furthering your own interest at the cost of the company, and that's malafide action which gives rise to liabilities as a director. Next. Duties of the directors. Now, the Companies Act for the first time in India the new Companies Act has laid down certain specific duties under Section 166. And of course, the duties of the independent directors have been separately carved out under Schedule 4 of the Act. And the duties have been actually enshrined in the Act on the basis of the report of the J.J. Irani Committee, which went into the review of the Companies Act 1956. In my opinion, 166 is a watershed provision in the sense that for the first time, the duties of the directors have been spelled out, and quite obviously it follows that if a director is not complying with the duties as laid down in the Act, the liability straight away comes to him. On the other hand, in the previous Act, there was a very indirect reference to duties of directors. In fact, Section 312 of the previous Act only talked about the duty of the director not to assign his office to any other person. That means that if I am a director on the board, I cannot tell somebody, chum, you look after my duties from tomorrow. That is what was only prohibited under the old Act under Section 312. Now the law specifically speaks about several duties, and Section 166 is a verbatim reproduction of Section 171 to 175 of the UK Act of 2006. Let us look at what are the duties of the directors as laid down under Section 166. One is to act in accordance with the articles. The Articles of Association, as we know, are the bylaws which regulate the internal management of the company, and the powers of the directors are generally derived from the articles, and their duties also stem from the articles, and therefore their first fundamental duty is to ensure that they act in accordance with the provisions of the Articles of Association. Next. Now, as I said, the fiduciary duty of the directors make it obvious, make it absolutely necessary that they act in good faith. They should always act in the interests of the company. They should seek to promote the objects of the company, which will be for the benefit of all the stakeholders. The third is that there has to be an exercise of ordinary prudence and rationality. Now, what is ordinary prudence? How do you define ordinary prudence and rationality? Now, these are not expressions which can be defined under law. And what is the law saying in matters such as this, where there is a definition which is impossible? When something cannot be defined, obviously you go by the the common law definition. What is ordinary prudence? Suppose we know that when you embark on a train journey, you know that you are supposed to buy a ticket. Now that is ordinary prudence. You know that it is rational for you to buy a ticket. You don't enter a train with a platform ticket. That's an example where you are exercising ordinary prudence. What would you do if you supposing you bought a platform ticket and entered a train, then you would be liable for huge penalties. So that is exactly why it is said that you are supposed to act in a manner as if the company belongs to you, and you exercise that amount of prudence which a man with normal rationality. I'm not saying that you have to be always an Einstein to discharge your functions as man, but you should exercise that degree of prudence which is expected of a man of some amount of rationality. However, that does not suggest that while managing a company, there will be no judgment, there will be no errors which are judgmental. You may make several mistakes as directors. The board, in fact, there is this 80-20 rule which says that only out of most of the decisions you take, only 80% turn to be correct. And so can you be always held responsible for any error that has been committed by the board? No, the answer is no, because if the error has happened, in fact, I will talk about a rule which is originally from the United States, which is called the business judgment rule, which is also applied in India to some extent. But if there is a judgmental error which is genuinely born out of an erroneous belief of the circumstances, you cannot be held responsible as long as you have discharged your duties with the degree of prudence and rationality which is expected of you. And the next duty is that the directors are not supposed to be involved in situations which give rise to interest, or which give rise to a conflict in interest which is there is a conflict between their own interest and the interest of the firm, in which case you are always supposed to sacrifice your interest and do an act which is for the betterment of the company. Like for instance, if you are a director in a cement company, and if your wife has a cement agency, obviously, if you have appointed that particular agency as a cement agency, in that case, clearly there is a conflict of interest between you. The wife is your alter ego, and therefore, given the fact that there is going to be a conflict, this gives rise to a contract which is with a related party. And that is exactly why under law, you have a provision under Section 177 of the Act for the audit committee to approve related party transactions. And then under Section 188, also there are several contracts which have to be approved. And then under the SEBI regulations, where you are talking about material related party transactions, you have to take the permission of the approval of the shareholders, and related party cannot participate to vote affirmatively in such transactions. So you should not give yourself to a situation where you are in conflict with the interests of the company, and if that is so, your interest will have to be sacrificed at the altar of the company's interest. Next. You will not be allowed to make any undue gain or advantage for yourself, relatives, partners, associates. And if that happens, then there is a provision for disgorgement of assets, disgorgement of benefits. Suppose you have made a killing in the stock market through your relative because you had some access to price sensitive information, then you will be liable for prosecution under the Prevention of Insider Trading Regulation, and whatever gains that you have made will be disgorged, and that will be transferred to the Investor Protection Fund. And again, you are not allowed to assign your office. Now, what is assignment? Assignment, supposing I am the director, managing director of the company, and I'm getting in age, and I'm 75, and I nominate my son to be a director, to be a managing director after my tenure is over. Now, the nomination of a son does not necessarily result in assignment. Similarly, the appointment of an alternate director for an original director also does not tantamount to assignment. Okay, assignment is where you abdicate your responsibility and give the responsibility to somebody else, and that kind of assignment is void in law. Similarly, when I issue a power of attorney to others for doing certain functions, in that case, it's not assignment, right? And there is a cash penalty normally for contraventions, and most of the duties of the directors, as I said, because of the fact that there is a fiduciary responsibility, is the codification of the common law principles enunciated. Of course, in India, you don't have common law principles as you have in the UK, Canada, and others, but the decisions in the UK law where it comes to application of common law are applicable to an extent in the Indian context as well. Next. Application of common law principles. I now take you through to some of the judicial decisions where the director has been found guilty of breach of fiduciary responsibilities in jurisprudence. First, let us understand, as I said, that the fiduciary responsibility of the director is always to the company. The fiduciary responsibility does not extend to the directors advising the shareholders on whether they should invest in the additional shares of the company. Suppose you have a shareholder who comes to you and he's a friendly shareholder and asks you, boss, can I invest in your company more? And then you say, yes, you can do so. Then you will not be considered as having breached your fiduciary responsibility, because your responsibility does not extend to advising the shareholder on whether he should invest. And there is a case law which has exonerated a director which is in similar circumstances. Then fiduciary responsibility also does not arise if there is a contract with the company which is in conflict with the interests of the company, but it is not endangering the interests of the company. that is why you have related party transactions which are approved by the board, which are approved by the shareholders, and these are related party transactions which are taking place in the ordinary course of business and at arm's length. And you know, under the Income Tax Act, you have the harbor rules for arm's length pricing. And if you have abided by your harbor rules for pricing, in that case, the contract is at arm's length. And even if the contract is in conflict with the interests of the company, you will not be held responsible for fiduciary discharge, for failure to discharge your fiduciary responsibility. Next. Next slide, please. Go on. Next slide. Yeah. Again, you will not make any secret profits at the cost of the company. And as I said, if there is any secret profit, suppose you have given a contract to your wife's firm and there is a certain undercut by way of commission, that's secret profit and you are not allowed to do that. And you are there has to be disgorgement of such kind of a gains. The basic logic here is that whatever profit is earned actually belongs to the company and does not belong to you. Then, as I said, you cannot delegate responsibilities. Responsibility, even as per the principles of management, can never be delegated. It is only authority that can be delegated. Responsibility can never be delegated. Now, however, you delegate authority to a managing director. But that does not absolve the board of any responsibilities. And there is a Latin maxim which says, delegatus non potest delegari. That means you are, as a director, you are yourself a delegate of the shareholders, and you have therefore no right to delegate your responsibility to somebody else. Okay. So only authority can be delegated and not responsibility. Okay. And you are liable indeed for any illegal act. Suppose the funds of the company have been used for some immoral purposes or for illegal purposes, for hawala transactions and the likes, then you are liable for failure to comply with the fiduciary responsibility. Then similarly, bribery is an offense which is you are not allowed to give any illegal gratification for the purposes of fostering the company's interest. You say that I got an order for 100 crores by greasing the palm of a government official. Yes, the company got benefited, but you got the contract by illegal gratification. That you are not allowed to do. Next. Now, what are the types of, this is only an example. I have given only an illustrative, because I can talk until the cows come home. Where it comes to, the fixation of responsibility, I've just given you a sprinkling of what is the mind of the judiciary where it comes to, relinquishment of fiduciary responsibility. There are two types of action that can be taken against breach of fiduciary responsibility by a director. The first is derivative action, and the second is representative action. What is derivative action? Derivative action can be taken against the director where a director fails in his fiduciary duties in exercise of his powers. In that case, the shareholder can go to the court and the court can authorize the shareholder to sue the company in exercise of their rights. And here, the result of the derivative action goes in favor of the company. That means that if you find that the director has illegally done something, if he has failed in his fiduciary duties, for instance, if there is a special resolution which has been proposed, but one very important material fact has not been disclosed, then there is a failure to discharge a material information which results in the failure of a fiduciary duty. In such a case, the court can be approached by the shareholder, and the shareholder can direct the court to allow him to exercise his rights and negate that act, and in which case the relief goes to the company. The other is a representative action, which is very similar to what you take by way of action for oppression and mismanagement under Section 242, where the shareholder does not individually proceed. The shareholder proceeds. Of course, if you are a shareholder holding 1/10, then you can proceed yourself. Or if there are shareholders who aggregatively constitute 1/10 of the holding of the company, then they can proceed to the NCLT. In this case, not the court directly, the NCLT, where if there are any acts of oppression and mismanagement which have been committed by the directors, in that case, they can approach the NCLT for intervention, and the NCLT can give directions by which the directors are not allowed to proceed with the action. That is, so the action can be both derivative as also representative. Next. Now, derivative action has been allowed in the following cases as per jurisprudence. Now, where the directors have proceeded to take action on the basis of an ordinary resolution, where the law calls for a special resolution, in that case, the action is bad in law, and the restitution has been done to the extent the status quo ante has been restored. Like, for instance, when you want to borrow in excess of the paid-up share capital and free reserves under Section 181C, you need to take the approval of the shareholders by special resolution. Now, if you have taken the ordinary resolution, that will not be good enough, and then your action will be nullified. And in Fiduciary Cotton Mills, the court has directed that action shall not be proceeded where the company has taken approval by ordinary resolution, where a special resolution was called for. Similarly, derivative action has been allowed in case of ultra-virus acts and illegal acts, where you have committed as a board anything which is ultra-virus the company or the act. In that case, the shareholders have a right to expect that the company, because the shareholders have a right to expect that the company shall be run as per the constitution of the company, you are allowed to intervene and derivative action can be allowed. Similarly, the board can be restrained from action which is ultra-virus the board, but intra-virus the company. Then the board can be told that you go to the shareholders, take the permission of the shareholders, and then do the act. You cannot take action without the permission of the shareholders. Next. Now, derivative action has also been allowed in cases of fraud, because you are supposed, there is this major principle which was carved out in the English decision in Foss versus Harbottle. Foss versus Harbottle says that the majority will normally prevail. But if you are perpetrating fraud on a minority, that principle will not stand. So if the managerial powers are being used in a manner to throttle the authority of the minority shareholders, in that case, the minority shareholders can be allowed to take action against the board and the company. Again, when you're transferring control over the company, supposing, you see, under the law, if you are a listed company, if you want to sell if you want to sell an undertaking, not necessarily a listed company, if you are even an unlisted company, if you are selling an undertaking of the company, what is an undertaking? Undertaking is a productive organism. If you are selling an undertaking such as a factory, which is going to give you productive assets in the form of income, flow of income in the future, if you are going to transfer control of the assets of the company, or you're selling your controlling interest in the company without taking certain permissions, then in that case, you are not allowed to do so. Like, for instance, if you are seeking to sell in the context of a listed company, 26% or more to somebody else, that somebody else has the requirement to make an open offer. So you will have to comply with the requirements of the Act where it comes to transfer of ownership of control over the company. And if the board has clandestinely passed any resolution for transfer of controlling interest without seeking the sanction of the shareholders, in that case, that action shall be nullified and derivative action has been allowed. Next. When you see, there are cases where the directors have delayed making the calls on the shares, because they do not have the money to buy their own shares. You see, under the old Act, if you remember, under Section 270, there was a requirement for the directors to hold qualification shares. Now, if the director did not hold shares in the company, under the old Act, he could not be a director if the articles provided for it. Now, in one particular case, the directors delayed making of calls on the shares. These shares were partly paid because they delayed the calls because they didn't have the money, or they had actually defaulted on their own calls. Now, here was a case where the derivative action was allowed because you are actually doing something which is detrimental to the interests of the company. Again, when you are selling your assets on the basis of an obvious undervaluation, that is exactly why when you're selling assets, there is a requirement under various provisions of the Act for a proper valuation. Even where it comes to a case of scheme of arrangement or amalgamation, there is a requirement for valuation. And that is exactly why this requirement is there, that there should be an independent valuer who will assess the value of the assets of the company, so that you do not end up selling the assets in an obvious undervaluation so as to generate some secret profits which are under the table. Again, when the company is under insolvency and the directors have held themselves to payments such as gratuity, and the company is in dire straits and is unable to discharge its obligations, and the directors have held themselves to hefty salaries, gratuity, etc., derivative action has been allowed. Next. Now, again, diversion of funds. Now, you cannot divert the funds of the company for a sister concern, without taking the approval of the board and the shareholders under Section 186. Even loans to your wholly owned subsidiary today under the law is not allowed on zero interest rates. And the law says that even if you provide interest loan to your own wholly owned subsidiary, in that case, you will have to charge interest which is equivalent to the rate which is applicable for government security according to the tenor of the loan. Similarly, when the directors, by virtue of, suppose because of the fact that as a director, I have the majority control over the company, I own more than 51% of the capital, and therefore I am able to divert business opportunities for my own interests. I have set up another company where my son is running the company, and I divert certain opportunities which have come to me, to the company, to that company, so that that company will prosper. In that case, this is again a case of non-compliance with the fiduciary duties, and derivative action has been allowed. And again, where the majority power is used for the purposes of stifling the minority, as I said, the rule under Foss versus Harbottle will not apply. Next, please. Examples of, again, some more examples are there where you are improperly rejecting votes. Of course, now it is not possible for you to do because of the e-voting, and there is a requirement of an independent scrutinizer. Previously, when there was proxy wars and votes were counted by people that were close to the management, if there are votes which were genuine, which were rejected by the chairman for the purposes of stifling minority, that has been held to be wrong. Similarly, issue of shares mala fide with the intention to increase control. Like, for instance, you issue shares with disproportionate voting rights. Say one share for a promoter is equivalent to 10 votes. Now, that is not allowed under the law. Again, if there is an exclusion by the majority of the directors, if the minority director in the board is ignored for all intents and purposes because he is overpowered by the majority of the directors. And when wrongful acts have been committed for the purposes of running the business by those who are in control, but the minority is unable to institute proceedings against wrongful acts, these are examples where derivative action has been allowed. Next, please. Am I allowed some time, 10 minutes extra, or do I have to close at 6?
No, sir, you can continue. No, that is not
I can continue because this is a very long subject, and normally I am not inclined to be verbose, but what I am trying to say is only relevant to the subject. So therefore, I want to spend, let's say, about 10-15 minutes extra. Okay?
Sure, sir.
Again, where has derivative action not been allowed? So, it's not always that the directors can be held responsible. If I am infringing on the personal rights of the shareholders, such as interference on the right to vote. Suppose I tell a friend of mine, yeah, you vote for this resolution. In that case, it cannot be considered as violation of my fiduciary duties. And again, if there is expropriation of company's property for their own use. Now, suppose a company has given me a car and it is ostensibly for official use, but my wife is using it for shopping. Now, the law cannot be, you see, the law can never be, it can only be a watchdog. It can never be a bloodhound. So can the registrar of companies constantly, track the movement of a car to see whether the car is being used only for official purposes? So expropriation of the company's property. Now, if the company has given me a house for my wife and family to live, but there is a guest who is staying on. Now, is that wrong? I mean, is it such a heinous crime that I will be prosecuted? Again, where the directors, you see, this is very important. Where the directors have applied their minds in drawing up the financials in good faith, if the financial results of the company are bad, but yet I have complied with the financial accounting requirements, the accounting standards which are applicable as per Ind AS have been applied, and yet the results are not good, in that case, you cannot hold the responsibility. If the company is not doing well, in the midst of COVID, how many companies went under the rug? How many companies have disappeared from the map of the country? Now, could you hold the directors responsible? Now, again, where the directors have decided on the place of the meeting, for the, an extraordinary general meeting today can be held not necessarily at the registered office of the company, it can be held anywhere else. So if the directors have held the meeting at a place where shareholders cannot easily access, you can't say that they have done it deliberately for not allowing the shareholders to participate. And there is a case law, it says that if the directors have decided on the place of the meeting, you cannot hold them responsible and allow derivative action. Next. No derivative action again is allowed where the directors have decided to distribute dividend while their debts remain unsettled. See, no company can remain in a situation where it has absolutely no debts. Debts are always going to be there in the concept of a going concern. So if the directors have decided to distribute dividend, which has been approved by the shareholders, when there are certain debts which remain unpaid, in that case, you cannot hold them responsible. Again, where there is a complaint as to the manner in which the profits have been determined. See, the accounting, the concept of profit in accounting, in spite of all the, nuances which have been carved out, all the professionalism that has come out, there is no situation even today where the law tries to distinguish between profit which is sustainable and non-sustainable. Of course, many better companies have the habit of disclosing non-sustainable profit as one-time earnings, but many companies do not do so. And even if you have declared dividend out of one-time earnings, the law does not say you cannot declare dividend out of capital profits. So if there is a complaint in the manner in which the profit has been determined, in spite of the fact that the company has complied with the rules relating to accounting, in that case, you cannot be held responsible. Similarly, court will not interfere where the directors have decided to use the company funds as per the authority granted. Suppose the directors embark upon a plan for a diversification of the business of the company, and unfortunately, the diversification plan does not take off, and despite their bona fide, it has gone fud. Then you cannot hold them responsible. Next. No to derivative action is there when there is a negligence in management which has been alleged without substance. You say that the management is responsible, is negligent, but you are not able to prove negligence with substance. In that case, Foss versus Hot Bottle will not come to your rescue. Again, where action has been taken for dilution in the firm's valuation, if you want to dilute the value of the firm, in spite of the fact there has been no negligence on the part of the board, no derivative action is allowed. So again, as I said, the company suffers loss. It does not mean that the directors have not performed their judicial fiduciary duties. Next. Now, let us look at, what I said was liabilities which are for all kinds of directors, and let us look at certain carve-outs under the law for liabilities specifically for independent and non-executive directors. Now, today we have the requirement under law for under 149 as also under the listing agreement for a certain number of independent directors. And for having non-executive directors who are not part of the promoters, right? What is the liability for such directors who are independent and non-executive and who are not related to the promoters? Now, there is a provision under section 149(12) which insulates such kind of directors from any action for any negligence under the provisions of the Companies Act. Mind you, 149(12) will come to the rescue of an independent director and a non-executive director only in respect of actions under the Companies Act. And 149(12) has a non-obstante clause. It overrides all other provisions of the Act, and it applies to independent directors and to non-executive directors who are not part of the promoters or KMPs. So KMPs, promoters are not allowed insulation under 149(12). Now, what is 149(12) speaking about? It says no liability can arise to an independent director or to a non-executive director for any act or act of omission or commission. If the board has committed any act where there is omission of a certain provision or commission of a certain act, unless that act is happening with the knowledge of the independent director and that knowledge is attributable to the board process. Like for instance, the board have proposed to increase the borrowing powers and you are an independent director and you are sitting in the board and you did not say anything despite the fact that you have knowledge that you cannot borrow in excess of the capital and free reserves without the consent of the shareholders under section 181C. In that case, you cannot be exonerated from liability. But you acted bona fide. You said that no, you cannot do so because you have to take the permission of the shareholders. And you wanted that your note of dissent should be recorded in the minutes. In that case, you have applied your mind, you have applied your knowledge, and then you will be insulated from responsibility in such a situation. So if there is a noting in the board to the effect that you have sort of voiced your dissent, in that case, that is a clear case where you have not gone along with the board and you cannot be held responsible on the ground that you are a party to the omission or commission. Next. They again, connivance or consent. See, if you have not objected to, in the example which I gave you, if you have not objected, it means, you see, in the contract law, it is said that silence is equivalent to speech, where you are talking about section 17 under the fraud, for fraud, silence is equivalent to speech. So if you have not said anything to, oppose this proposal to do a borrowing which is not within the four corners of the Act, then you cannot claim insulation. Again, if there is no, the insulation comes if there is no absence of diligence. And of course, this has to be proved circumstantially. You have to prove circumstantially that I did not participate. I did insist on a note of dissent, and I wanted that it should be recorded because minutes have evidentiary value in a court of law. And if you want to defend yourself, you can say that, look at the minutes, Mr. Chairman, my lord, I have made my dissent open, and therefore I will not be exonerated. I will be exonerated in such a situation. The insulation under section 149(12) will also apply to nominee directors, although nominee directors under the Companies Act today are not independent directors, but nominee directors who have been appointed under special acts like the Unit Trust of India Act, the LIC Act, etc. There is a specific provision under these acts that they will not be held responsible. The nominees of these institutions shall not be liable for any contravention of the Act. Of course, here again, they have to display the ordinary diligence and prudence. If they are personally involved then the installation will not come. And there is a decision in the case of Selvaraj versus RBI. Here, of course, there was an economic offense where the independent director clearly proved that he was not in any way involved in the day-to-day operations of the company, and he cannot be therefore responsible. The court held that as I said, the theory of alter ego says that only those persons who have the control over the affairs of the company shall be considered as having the authority to manipulate the affairs of the company, and those alone shall be responsible as per the Supreme Court in Airtel India. Again, if there is no material, again, one of the defenses of the independent director is that an independent director actually comes to the board only once in 3 months, or more than that if there is one more meeting which is happening in a quarter. So if there is no material to show that the independent director is actively involved in the day-to-day affairs of the board, in that case, you cannot hold the independent director responsible. Now, however, I need to point out to all of you a very important change which has happened in the not in the Companies Act, but in the SEBI law, where it comes to related party transactions for listed companies. Regulation 23(2) says now related party transactions have to be approved only by independent directors who are members of the audit committee. So therefore, if you have got 6 independent directors on your board and there are only 3 independent directors who are on the audit committee, if they have taken an approval for the related party transaction, and if the transaction bombs, in that case, they would be actually responsible, because they cannot say that they have not applied their mind. To my mind, this, with all humility, let me say that SEBI have not done the law correctly, because by definition, an independent director is a non-executive director. And if you are asking him to approve a related party transaction, you are actually asking him to do an executive action. You are asking him to take an executive step, which he may not be able to, because he is not familiar with the company's operations. So you are making him do something which is not his part of his domain. So with due humility, let me say that SEBI have got it wrong where it comes to Regulation 23(2). Next. Nominee director's responsibility. Again, the SAT tribunal has held that the independent director cannot be responsible for refunds of money which have been collected in contravention of the Act, where such payments were received prior to his appointment. Unikrishnan Nair versus SAT tribunal. Suppose the company had made an issue of capital which was not in consonance with the ICDR regulations, and which resulted in refund of money, and that happened before the director's appointment. In that case, he cannot be held responsible. Now, nominee director's liabilities, as I said, the nominee director is not an independent director under 149(7), inexplicable, because under the Companies Act of clause 49 of the listing agreement, under the old law, a nominee director was considered as an independent director. I don't see why he should not be, also given the fact, and you see the JJ Rani committee says he cannot be considered as independent because he is representing a constituency. He is representing a constituency of lenders if he is appointed by the public financial institution. By the same token, under section 151 of the Act, the shareholders, the small shareholders, are allowed to appoint an independent director. Now, he is also representing the small shareholders. He is also representing a constituency of stakeholders. Ironically, a small shareholder director is an independent director, but a nominee director is not one. This is a paradoxical situation in the law, which I cannot accept. There is no logic in this. Next. Nominee directors, as I said, they are not independent. Now, how are they supposed to respond? In case of a conflict of interest between the company and the institution whose interest they represent, they should always focus on the interest of the company and not necessarily look at the institutional interest, and they have to look at the interest of the company, at the same time try to marry the interest of the nominating institution with the interest of the company. And there's a classic case of English law, Scottish Cooperative Wholesale Society versus Mayor, where there was an error on the part of the nominees to protect the interests of the nominating society. There, the court held that you should have protected the interests of the company and not those who nominated them on the board. Next. Conflict of interest again can happen. Now, here again, you have to, as a nominee, ensure that you are acting in the interest of the company and not for the institution that you are protecting its interest. And as a nominee director, of course, you are answerable to the institution, but that does not mean that immediately after a decision is taken by the board, you have to telephone the LIC and say, this is the decision that has been taken. The company has taken a decision to go for a bonus, so buy shares of this company, like it happened in the case of Rajat Gupta. You can't do that. You are bound by the rules of board confidentiality, and you are not allowed to share information unauthorizedly. You cannot share information even with your nominator in an unauthorized manner. Next. The nominee directors have actually similar immunity under Section 149(12). And there is also a DCA circular under the old Act where the nominee directors will not be considered to be disqualified under Section 274(1)(g), that is non-filing of the annual return, non-filing of the balance sheet, etc., under 274(1)(g), which corresponds to 166(1)(d) of the present Act. As long as there has been exercise of good faith, the exercise of good faith is a common denominator which applies to all directors. And if the nominee fails in the application of good faith, then liability is fastened, as held in Gitanjali Mills versus Thiruvengadam. And you cannot have immunity if you are personally involved in the default as a nominee director. Next. Criminal liability, I have repeatedly said, the law has now been, sort of softened based on the report of the high-powered committee. The law has decided that where it comes to technical offenses under the Companies Act, there shall be no criminal liability fastened. The criminal liability will happen only for offenses which are non-technical in nature, which is why most of the offenses have been now transferred to the adjudication mechanism and to penalties which are cash in nature, which are compoundable. And I already explained where vicarious liability comes, and the vicarious liability has been the principle of alter ego has been explained in Bharti Airtel. For those who want to go through the Supreme Court decision and the principle of alter ego as enunciated, you can go through this very interesting judgment where the court says only those who are palpably in authority can be proceeded against for criminal activities. Next. Now, having said that, I have more or less covered all the liabilities to which the directors are exposed. Now, how do you insulate directors? I know that, you see, being a director is not a piece of cake. Today, do not assume that I can walk into a board of a company which is, let's say, managed by Nirav Modi and still escape responsibility. But there are companies, better companies, where you can, depending upon the antecedents of the company, you can join without any risk. But how do you insulate? Even in such companies, there is a need for an insulation mechanism for directors, and the insulation mechanism is laid down under the Act itself. Regulation 2510 in LODR provides that for the top 1,000 companies, please make it 1,000 companies, 2510 says that the top 1,000 companies based on market cap have to provide for a director and officer insurance. D&O insurance has to be taken for against the directors and independent directors at that. And I would advocate, in fact, in ACC, we had the D&O policy to cover all directors, including executive directors and KMPs, right? Now, the D&O insurance should be taken, the policy should be approved by the board, and the coverage should be also approved by the board, and the insurance premium that is payable shall be borne by the company. However, if the director is desirous of wanting further insulation over and above what has been covered by the company, he has to pay for it, right? And the responsibilities, you see, how can you insulate the board? Under section 260, you can fix responsibility on the whole-time directors, managing director, and the KMPs for specific duties. In that case, you get exonerated. Like under the, the ESI Act, the managing director has been held by the Supreme Court to be the principal employer, and for non-compliance with the requirements of the ESI Act, the managing director shall be responsible. Again, section 149(12) insulates independent directors, as also the nomination by the institutions also protects the nominee directors. Next, please. Yeah, there are how do you see these are created insulations. Now, there can be self-created mechanisms. How can you create self-created mechanisms? That is possible if you have a strong and independent board. Like, for instance, I'll give you an example in ACC. We had a board which consisted of, huge personalities, right from the chairman of LIC, SAIL, etc. There was one example where corporate governance was exemplary in a matter involving a related party transaction with the holding company. The materiality threshold was not touched. You see, we were paying royalty to the holding company at 1% of the consolidated turnover. 1% of the consolidated turnover was actually 130 crores, and 10% is the materiality threshold for ACC. The consolidated turnover at that point of time was 18,000 crores. So you could pay up to 10%, but yet for this payment of 1%, we went to the shareholders and sought their approval, and there was a huge possibility that the resolution may not succeed because the holding company could not vote, and they had 54% holding in the company. Yet the majority of the minority, including LIC, voted in favor. And therefore, if you have a strong and independent board, that itself creates an insulation mechanism. Again, you have to have a diversity of talent in your boardroom to ensure that all fences are protected. You have to have a lawyer, you may have an accountant, you may have somebody who's an expert in the environment, somebody who is an expert in HR. If you have a diverse board, then there is a possibility of insulating the board against. Then you have to have a very strong legal compliance system. We had an online, legal compliance tool. Many companies have introduced these tools of online compliance, where the click of a mouse, you are able to find out what compliances have been made. All the returns that are filed are online transferred into this mechanism so that the board member can become aware. And we had this, we had a system by which, there is this concept of a balance sheet approach where there were 17 cement plants. All the 17 cement plants' legal compliance mechanism reports were put on the table, and we had a ranking system by which we awarded the best rank to the best managed plant in terms of legal compliance. Now, if you have a person of preeminence, I'm not talking about a Vijay Mallya, but I'm talking about somebody like a Ratan Tata or somebody like an Narayan Murthy. If you have persons of preeminence who are there, don't take the example of Satyam. Satyam had a board which was consisting of huge, important people, but yet that gentleman, took the board round in circles. So if there are sound board practices, if there is a proper compliance management system, if you have a proper secretarial practice, if you have got proper agenda, if you have got agenda notes which are coming in time, and there is a good remuneration package for the directors, including payment of commission, which is based on net profits. And today, even if you have not got profits or absence of or inadequacy of profits, the independent directors can be paid remuneration to the extent of 24 lakhs, I think, in the Schedule 5. So if you have a good remuneration structure, the directors also feel that they are compensated for the amount of responsibility that they are taking. So as they say, if you throw peanuts, you will get monkeys. So you have to ensure that there is a good remuneration structure. And you have to have a compliance committee of the board so that, the compliance committee goes into the compliances on a regular basis and alerts the board on, any non-compliances. And of course, it is important as a company secretary. The company secretary has an extremely important role to play. He should routinely inform the board about the changes which have happened, in laws. There is a paradox. In ACC, I made a 3-hour presentation on the amendments to the LODR. There was another company where I worked, where I prepared a presentation on the Companies Act for 2013 for 5 days, and my presentation ended after 5 minutes because the chairman could not stand it. He said that, no, I don't want to understand, right? So there are, both sides of the coin. Next. Now, as I said, there is the impact of decriminalization of offenses, and the law has understood that you cannot have criminal offenses you can't be hauled up for technical offenses. Even under the CSR, CSR, if you fail to pay 2%, then you were liable to imprisonment. But now that is not that has been mercifully reduced to a fine. So if there are technical offenses, procedural offenses, minor non-compliances, and in that case, you will be only exposed to some cash penalty. And this is a good sign that has happened where it comes to the law, which has been, made substantially friendly where it comes to imposition of fines. Of course, I am aware that there are still some registrars who are trigger happy and want to impose. The other day, the registrar imposed a penalty of 10 lakhs on a private company in Bangalore, which did not appoint a CFO, without realizing that Section 203 did not apply to a private company, right? Next. The decriminalization, no, I will not explain the adjudication framework because it's too much. Under 454, an adjudication framework has been introduced by which the registrar can adjudicate on compounding cases. And the result is that there is going to be a huge amount of declogging of the NCLT's pressure is going to be substantially reduced. There was a funny notice I read in the social media the other day in the NCLT court in Calcutta, where the court was adjourned because the council, explained something silly, and the board member was feeling too tired, and he adjourned the proceedings. And for God's sake, let's not have such kind of orders. And criminal proceedings are there only when there is a malafide intent, and as I said, there is the principle of alter ego, right? Next. Amendments, there are several criminal offenses which have been converted into civil offenses, and this is a harbinger. Law can, as they say, I will end my presentation with the beautiful words by Rousseau. The French philosopher Rousseau said, man is only born free. Man is only born free. Everywhere he is in chains. See, why do you have law? Law is actually a facilitator for rational action. Law cannot lead you to business. It will only lead you to rational action. So it is necessary that you should have a process of self-regulation. For God's sake, do not start your car when there is a red light. I mean, if you want to think that you own the road, sorry, you are making a mistake. Even the chief minister stops today at a signal. So let us have self-regulation. And as they say in law, there is one principle I keep repeating whenever I speak. What is not prescribed in law, please understand, what is not prescribed in law is not necessarily prescribed in law. Meaning that the law does not say that the law says that you don't start the car when it is red, right? But the law also doesn't say that you can drive on the wrong side. But if you don't drive on the wrong side, it's a process of regulation, self-regulation. So what is not prohibited in law, or what is not prescribed in law can be practiced. You can always walk the extra mile. And what is proscription? Proscription is something which is restricted. If you want to be self-regulatory, law is not going to stand in the way. If I decide that I shall not take, God has been kind to me in 42 years of my professional life, there's been not one example of where I have compromised on my integrity. Now, to that I don't wear a crown. Now, that is something which came to me as a self-realization. That I did despite the provocation of the corporate sector. So please do not be complacent because there is now a process of self-regulation. The reduction of fines should not lead to a situation of complacency. Acha, theek hai yaar, fine to dena hai, de do. Let's file it late. Let's not do this. Please remember, the cost of non-compliance is far greater than the cost of compliance. And non-compliance is like a double-edged sword which cuts both ways. Thank you very much. I end my presentation with this. And if you have any questions to ask, I can happily field them. Otherwise, thank you very much. I know I have overstepped my time, but the topic Sumit gave me is such that I can't cover in 1 hour. And I assume that I have been only talking sense and not nonsense. There is a friend of mine, I keep telling him about, he was my fellow in Jadavpur when we did management. And that was a time when Sumit, this lady who's now in relationship with Lalit Modi, Sushmita Sen, she won the Miss Universe award. And this friend of mine was Saurav Sen. He said on that day, only the sense of the world make sense. Others are nonsense. So I don't have a surname of sense. So I don't assume that I have made nonsense. Thank you very much.
Thank you, Ramaswamiji. Thank you for that wonderful session and in-depth deliberation on the liabilities of directors under Companies Act 2013. I think we don't have any questions as such. So I would like to offer you a small e-memento.
Why e-memento? Please send it. It's a nice memento. I'd like to own it.
Yes,
The last time I spoke, it was sent by post. And I like this. This is a very nice. These days, I receive only, Shahid Ki Beti certificates from the institute. This is a good memento for my mantelpiece.
Okay. I'll convey the same. Thank you so much, Ramaswamiji. Thank you so much for being part of the 2-day corporate law conclave organized by ACA. With this, I think we can conclude the session. I would like to thank Ramaswamiji and all the participants for joining the session. Thank you so much.
Thank you. Thank you. Bye-bye.
Thank you.